these melons and the compelling and grave urgency I mentioning this matter melons. My second-hand car, which was being transported from Assam to Gurgaon.
Your personal car?
My client's car was intercepted here, and the responding authorities had imposed tax as well as penalty.
When
intercepted before minors, we filed a writ petition.
When intercepted
in May minors. We filed a writ petition, although there was an appeal provision, we filed a writ petition challenging the jurisdiction which was allowed, admitted. And after the direction was given, we were not, whatever the direction was given, we were not satisfied with the interim relief, so we moved manual appeal before the principal bench, before the Chief Justice. He directed that this matter be the state to file the affidavit not later than 7th of July, and this is the order passed and to be resolved after 10 balance. You allowed this functioning. This matter is appearing as item number 129 balance. Kindly balance if you take this up to date, any time balance as per your convenience.
Yes, we enlisted. Let me see.
Wait.
But motion relates to library services manner. The returnable date was today manner, but it is not even listed.
So hearing what?
No, motion.
Returnable date.
The filing date was supposed to be listed.
What is the urgency?
But he is a retired person for 1.5 years here. The PPO has also not yet been.
No, mentioned before the next subject. Yes.
You don't have to not kind to mention one matter without with regards to item number 86 in the this is a tender matter. I have been illegally disqualified from the tender. I am the highest bidder. Bid has been paid. I am led by Mr. Rodinelli. Your Lordship, kindly hear out this matter. Otherwise, my repetition will become.
It is appearing in the list. Let me see how far.
My learned friend is appearing.
Let me see how far I can read.
If the matter is not heard out, my meeting will become infructuous. But I am the highest bidder. I have been terminated because of illegally terminated. My fundamental rights have been violated.
Okay, that's why it has been accommodated in the list. Let me see how far I can.
Kindly fix any date, time, as per confidence of the Lordship.
Yes, any other answer?
Anytime tomorrow.
Yes, it has been listed. Let me see how far.
May I be mention one matter? Yesterday, Mr. Jalpaiguri mentioned a matter into the Lordship matter. The matter relating to a license vendor of New Kuchbihar railway station. He was a license vendor. After expiry of the license, he applied for renewal of the same. That was not considered. A petition was filed, and petition was dismissed. Subsequently, the appeal was referred. In the appeal, after hearing, that was remanded back, and the last option was taken up, and it was appealed under hearing. It's urgently because during pendency of the petition, now they are trying to oust me on the particular.
It's not possible in this case. There is so many matters. Mr. Rai mentioned next circuit. Next circuit. Yes, you have the option to mention. Maybe at the end of the tag end of the target. See the length of the list. See the length of it. There are matters where Supreme Court direction is there. I have tried to accommodate these matters in my own way. Let me see how far
the issue that not a poor person you will use in the army.
try to mention it. See the length, otherwise matter could have been taken.
In today's case, item number 124. Can one is appearing in the list under the heading for application.
It will be better to move before the next. I have expressed my view. I am telling you from my own experience.
The next one is what entered in the recalling application.
Yes.
The next circuit, the honorable just won't enter into the recalling.
Why not?
If
If it is not, then if it is transmitted to the principal bench after their refusal, then you mention this one.
tomorrow, if possible, it will stop.
The last date is sorry.
My current account is after permission.
What can you say? You try your luck before the next circuit. That will be better for you. Because I have expressed my mind, but on technically, if it is fine that now recalling applications are being taken up by the regular ones, like restoration applications.
That's right. But generally,
That will be better for you. Mention, yes, all the list.
Item number 1. By telecom.
Yes, what for it has come?
For correction of the name of the speaker.
What correction you require?
It is stated Mr. Devopita for the state. It will be Mr. Kumar Sinha with Mr. Babu Zama, Mr. Devopita was from the state.
He appeared for Siliguri Municipal Corporation.
Yes,
This matter has come up in the list. Whether you have mentioned this matter for correction, matter has come up in the list at the instance of the learned advocate representing the state respondent. State respondents. And accordingly, represent the state respondents for correction and according to the representing the state respondents for correction of the order dated 7 July 2023. Stop. Next paragraph, at the time of next paragraph, time of the learned advocate representing the state respondents submits that inadvertently names of the learned advocates who were representing state respondents were not recorded in the order dated 7 July 2023 and name of the learned advocate representing Siliguri Municipal Corporation had gone down in the order. As an advocate representing had gone down in the order against Siliguri Municipal. Stop. Next paragraph. In view of the aforesaid submission made on behalf of the state respondents, let the names of Subir Kumar Saha, learned advocate. Let the names of Subir Kumar Saha, learned advocate, and Muminur Rahman, learned advocate, be recorded against state respondents and name of name of Devorshi Dhar, learned advocate, be recorded against Siliguri Municipal Corporation. Next paragraph. Department is directed to incorporate necessary correction in the order dated 7 July 2023. Let this order be. Let this order forms part of the order dated 7 July 2023. This order forms part of the order dated 7 July 2023. Yes. It was disposed of. No, I didn't like it. Yes, that clear. It further appears that one application being can 1 of 2023 is still pending. Stop. In view of the order passed by this court on 7 July 2023. The connected application being can 1 of 2023 stands this photo.
Item number 2, I am for the meeting. It is not claiming $1.
How much?
My God, 2,67,522. It is not the assets to be of high.
Were assistant teacher of high school. When retired?
My God, 30 April 2022.
Okay, PPO.
My God, amount deposited on
PPO.
my God,
Date
28 October 2022.
$257,522.
Yes. At 22.
Yes. Yes. I believe service filed in notice is given with the report is being reported. Next. Petitioner was an assistant teacher of high school who retired on superannuation on 30th April 2022. So after superannuation 2022 stop at the time of processing pension case of the petitioner. Respondent authorities calculated rupees 257,522 as excess on amount, which petitioner was directed to refund before release of return due. Stop. Petitioner deposited the said amount with the appropriate authority and the treasury challan was issued in favor of the petitioner showing such deposit. Stop. Subsequently, pension payment order was issued with a memo dated 3rd April 2022. Now, with a memo dated 28 October 2022. 28 October 2022. Releasing terminal benefits. Stop. Petitioner claims refund of alleged excess drawn amount which he had to deposit at the time of processing terminal benefits. It is next paragraph. The learned advocate representing the state respondents has opposed the prayer of the petitioner and has defended a decision of the state respondents to recover the amount from petitioner, since according to the state respondents, the aforesaid amount was paid to the petitioner in excess. Stop. Next paragraph, having considered the submissions made on behalf of the learned advocates representing the parties, it appears that direction needs to be given upon the Director of Pension Provident Fund and Group Insurance, being the respondent number 2. To take decision on the claim of the petition. So, petitioner is granted leave to file to submit a representation before the respondent number 2, claiming refund of excess drawn claiming refund of excess drawn amount within a period of 4 weeks from date. Stop. If such representation is made within the aforesaid period, the respondent number 2 is directed to take reasoned decision on the claim of the petitioner within a period of 12 weeks from the date of receipt of representation after granting opportunity of hearing to the petition. Stop. Next paragraph. At the time of taking decision, the director of the respondent number 2 shall consider the decision of the Honorable Supreme Court reported in 2015, Volume 4, ACC 334, within the state of Punjab and others versus Rafiq Mashid, whitewasher, within bracket whitewasher and others. Stop. The decision, next paragraph, the decision to be taken by the respondent number 2 shall be communicated to the petitioner within a period of 2 weeks thereafter. Next paragraph, with the aforesaid direction, the petitions can dispose of the extended knowledge to pertinent goods. Item number 3. Yes, tell me the details. Assistant teacher or primary teacher?
Assistant teacher of high school. Retired on 31st July 2021.
Just a minute. Retired on
31st July 2021.
31st July 2021. Then
And one PPO issued on my
single PPO.
single
Overthrown amount.
yes, sir.
PPO.
PPO my 16 November 2020.
Yes. Amount.
Amount 1,56,800.
Issue. So, assistant teacher of high school. Teacher high school retired on 31st July 2021. PPO dated 16 November 2022. Amount 16 PPO 16 November 2022. Amount which is 156,800. 156,800. এইগুলোকে বসিয়ে আগের যে অর্ডারটা দিলাম সেম অর্ডার করে দিন। Director of pension, we responded number 2. Same order, ঠিক আছে। Dispose. Item number 4. Assistant teacher of primary school. What is what you are claiming? Interest for getting single. Retired on 31st July 2021. 31st July 2021. Yes, ma'am. 31st July 2021. PPO 28 April 2023. Interest on gratuity. Yes. Affidavit service. Next, petitioner was a primary teacher who retired on superannuation on 31st July 2021. Stop. After superannuation of the petitioner, by issuing pension payment order dated 28 April 2023, pensionary benefits were released in favor of the petitioner. Petitioner claims interest on gratuity due to delayed payment. State respond. Next paragraph. State respondents are represented by learned advocates. Next paragraph. Accordingly, the Director of Pension Provident for Insurance and the concerned credit officer are directed to pay interest at the rate of 8% per annum to the petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of the same, within the period of 8 months from the date of communication of this order. Affidavit since no next three paragraphs will remain same. Next.
Item number 5.
And what the petitioner? Interest of gratuity matter single people. Single PPO interest on gratuity. Yes, madam. Petitioner is the assistant teacher of primary. Who is for the state? You are for the state. PPO retired on 30 June 2022. PPO 24 May 2023. Interest of gratuity. Issue. Petitioner the affidavit service. Next, petitioner was a primary teacher who retired on superannuation on 30th June 2022. After superannuation of the petitioner by issuing pension payment order dated 24th May 2023, retirement dues were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payments. Next paragraph. State respondents are represented by learned advocates. Next paragraph. Accordingly, the Director of Pension Provident Fund and Health Insurance and the state and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of superannuation in the date of release of the same, within a period of 8 weeks from the date of communication of this order. Next, the three paragraphs will be in the same.
6. Item number 6.
Interest of gratuity. Assistant teacher of high school. September 2022. PPO. 4 April 2023. April 2023. Giving interest on issue. Affidavit service. Next. Petitioner was an assistant teacher of high school who retired on superannuation on 30th September 2022. Stop. On superannuation of the petitioner by issuing pension payment order dated 4th April 2023, retired due to a release in favor of the petitioner claims interest on revised gratuity as per revised the petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph state respondents and representative learned advocate. Next paragraph, accordingly, date from pension, correspondent and Google sample the consent officer related to pay interest at the rate of 8% to the petitioner on gratuity from the date following the date of super in the date of release of the same, how we will get the vehicles from the date of molestation. So, based on the paragraph, we will explain this question.
Item number 7. And for the
Husband of petitioner
died in
died in harness.
No, man, died.
Died after retirement. Died.
After retirement.
Now, wife has come.
Yes, man.
Husband was working
Clerk.
of high school or where? Where clerk?
High school.
Retired on, husband retired. Husband retired on
29 February 2020. 2020. Yes, ma'am.
Retired on 29 February 2020. Then died. Or PPO was issued before his death.
PPO was issued on 4 June 2020.
4 June 2020. PPO was issued for then died. Then
That died on 19 May 2021.
19 May 2021. Now, wife is claiming interest in issue. State, yes, you are agree. Affidavit of service. Next paragraph. Petitioner's husband was a clerk of a high school who retired on superannuation on 29 February 2020. After date of the petitioner, after date of the husband, so 29 February 2020. Stop. After superannuation of the petitioner by issuing pension payment order dated 4 June 2020, retirement dues were released in favor of the husband of the petitioner. Stop. Subsequently, husband died on 19th May 2021. Stop. Wife of the petitioner has approached this court with the present petition, claiming interest on gratuity due to delayed payment. Stop. State respondent, next paragraph, state respondents are represented by learned advocates. Next paragraph, accordingly, the director of pension, provident fund, and group insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity, on gratuity from the date following the date of superannuation of the husband of the petitioner till release of gratuity within a period of 8 weeks from the date of communication of this order. Stop. Rest of the paragraph will be answered. Dispose of item number 8. I got the petitioner. Petitioner is a head teacher of high school. Head teacher or headmaster? Only claiming interest of gratuity. Exactly. Retired on
28 February 2022.
28 February
Yeah.
2022.
Yes.
PPO
PPO 9 December 2022.
9 December 2022. Claiming interest on gratuity. Issue. Affidavit of service. Next petitioner was headmaster of a high school who retired on superannuation on 28 February 2022. So after superannuation of the petitioner by issuing pension payment order dated 9th December 2022. Retired leaves are released in favor of the petition. Petitioner claims interest on gratuity due to delayed payment. Next paragraph with respondents are represented for the next paragraph. Accordingly, the director of pension provident fund and group insurance and the concerned reserve officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of superannuation of the petitioner till the release of the same comma within a period of 18 months of the common order. Rest of the paragraph will be say next.
Item number 9. This is a headmaster of I claim only means that for getting money.
Yes. Headmaster of high school.
Retired on 31st March.
First evening. Retired on
31st March 2018.
2018.
Yes, sir.
PPO
PPO in November 2020.
2020. Issue. Affidavit of service. Next petitioner was headmaster of high school who retired on superannuation on 31st March 2018. Stop after superannuation of the petitioner by issuing pension payment order dated 10th November 2020. Petitioner now by issuing pension payment order dated 10 November 2020. Petitioner 2020 retired dues are released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. State respondents are represented by Learned Advocate. Next paragraph, same. So I will get a bold one same. From the 8% from the date of from the date following the date of superannuation petitioner will get a release. Other set up for the petition. Next, disposed of.
The same the matter the matter relating to
Yes. Interest on area salary. Why? Let it be in this circuit. We have mentioned the matter has come up in the list. And why in the next circuit? Place your case, let him see. Tomorrow at the top 10:30. Let me see what is the prayer.
The petitioner joined the post of library side in the 1986 and subsequently application was made to the authority to pay the highest of it. But the authority did not consider because the data application in the 2017 the application was allowed and subsequently 2019 the highest of the government in favor of the petitioner. Amount was disbursed in the 2019. Let me consider my
Let it be decided on a period.
let me consider my claim. Last page.
Who will consider it this?
Director of library.
Because the area salary, area salary was paid for the period from 23rd August 1986 till the date of disbursement 29th of March 2019. When you retired?
It's a 70.
70.
70.
So this is not a pension.
No.
You are claiming interest on arrears salary. So let it be decided by the district inspector of schools or director of school education.
No, there's a library science.
Library side.
Yes.
There's a library here.
Yes.
Then who is the appropriate authority?
This,
This director of library services, West
Yes.
Bengal, decide the issue.
respondent number 2.
Yes, yes. Let him take a decision.
Yes.
He give me the details. Petitioner was a librarian
Yes.
in a school or in a
In
district.
a district library.
Yes, just clear.
District could be there.
Petitioner was a librarian in Obiguru Sangho.
Library.
Yes, just clear. Obiguru Sangho Library and has retired on superannuation. When retired?
Registered on 31st November 2017.
Where did it?
Page 47, I made a application 47.
Page 47.
Fourth line from the last, I retired from service on 31st.
Page 47. I was allowed to still.
Last four line, this paragraph last four.
কি বলছিলেন? On 31st October 2017. Stop. During tenure of service, there was a dispute with regard to payment of area dues to the petitioner, and ultimately rupees 1247,467. 1247,467 was paid to the petitioner on 29th March 2019. Stop the winner towards area dues. Stop. Petitioner claims interest on the aforesaid area dues due to interest on the aforesaid area dues. Stop. Next paragraph. Next paragraph. State respondents are represented by learned advocates. Who has opposed the prayer of the writ petitioner? Relating to payment of interest, relating to grant of interest on area dues, since according to the petitioner, the since according to the petitioner, area dues have already been released on 29th March 2019. Stop. 2019, stop. 2019, and the writ petition has been filed recently on 3rd July 2020. Stop. Next paragraph. In view of the rival submissions made on behalf of the parties, this court directs the Director of Library Services from West Bengal, being the respondent number 2, to take decision on the representation of the petitioner dated representation of petitioner dated 3rd May 2023, claiming interest on area dues within a period of 12 weeks from the date of communication of this order, and to pass the recent order. Stop. Before passing the order, the respondent number 2 is directed to grant opportunity of hearing to the petitioner or her, she or her representative. Stop. The decision to be taken by the respondent number 2 shall be communicated to the petitioner within 2 weeks thereafter. Stop. Next paragraph with the aforesaid direction of the petitioner and the school shall be more. Yes. Yes.
11. Number 11.
I have to put this now. Yes.
Petitioner claim what dollars?
How much?
1,04,098. Petitioner is the headmaster of primary
Head teacher.
head teacher. Retired on
Primary school, retired on
30 April 2023.
30 April 2023.
And I got if you issued on last June 2023.
First,
June 2023.
1st June 2023. Amount,
Amount I deposited on 15 May 2023.
amount,
1,04,938.
104.
Yes, sir.
104,938.
938.
এই শোনো আগে যে রিফান্ডের অর্ডারটা করলে রিফান্ড ওভার করবে ওয়ান্স আচ্ছা সেটা বার করে একটা অর্ডার দিবেন পেনশন রেস্টুরেন্ট ঠিক আছে
Based on an associated return to time processing pension.
ঠিক আছে ওইটা বেশ ভালো শুধু চেঞ্জেস হবে হেড টিচার অফ প্রাইমারি স্কুল এখানে হেড টিচার অফ প্রাইমারি স্কুল রিটায়ার্ড অন 30th April 2023 PPO dated pension payment order dated 1st June 2023 আর রিফান্ড অ্যামাউন্ট হচ্ছে ক্লেম করছে ক্লেমিং দ্য অ্যামাউন্ট which he had to deposit, so that is 104938. 104938. ঠিক আছে ডিসপোজ অফ
12. Number 12.
This is also made what?
Number six.
how much amount
2,29,9,825.
petitioner was
This number was an assistant teacher of primary school.
retired
On 30 June 2022.
2022
Yes, ma'am.
PPO
If you want your 2nd December 2022.
amount
Amount over 2,29,825.
229885 same order as petitioner was a primary teacher retired on 30th June 2022 PPO 1st December 2022 amount 229825 ঠিক আছে dispose of
Item number 13.
This is also my what?
item number 13 how much amount
My lord, 63,408.
petitioner was primary teacher
It is my lord, the assistant of high school.
high school teacher retired on
Return my lord, 30 September 2022.
2022
Yes, sir.
30th September 2022
And my lord, PPO it was on my lord 4 April 2023.
2023 amount
63,408.
63408 Resho. Petition number Yes.
Item number 6 was by the same name. This one was item number 13 same.
is one is filed claiming interest on gratuity, another is filed claiming.
Overdrawn.
What is this?
My lord, because
Then it should be by composite writ petition.
Yes.
No, certainly not. Why you have filed two writ petitions? One claiming interest on gratuity, another claiming refund.
overdrawn.
You withdraw this writ petition.
Yes, my lord, I would tell. I don't know what I need to.
Record an order. Sujata Nagarden rightly pointed out, Mr. Rama. It's not possible for the court to find out the name of the petitioner. Then at time of putting signatures, I had detected two matters previously. Heavy cost is to be imposed upon you for doing this malpractice. Please find out if there are similar names in the list. What is that the matter? Item number 6.
Yes, sir.
Yes. Record an order. At the time of call, learned advocate representing the petitioner submits on query that another writ petition was filed by the petitioner being another writ petition has been filed by the petitioner being WPA 1399 of 2023, which is appearing in today's cause list at serial number 6. At serial number 6, wherein petitioner has claimed interest on gratuity. So, the present petition has been subsequently filed, where filing of the previous writ petition being WPA 1399 of 2023 has not been disclosed. So, next paragraph. Furthermore, while filing the previous writ petition being WPA 1399 of 2023, petitioner would have claimed refund of amount which was paid by the petitioner at the time of processing his pension case on demand made by the pension sanctioning authority. Writ petitioner instead of lodging a claim or instead of making a prayer in the previous writ petition has filed another writ petition praying for refund of excess drawn amount. Full stop given, which is impermissible. So, next paragraph. Accordingly, the writ petition being WPA 1408 of 2023 stands dismissed. Urgent bill of settlement.
Item number 14. I got the petition. Interest of gratuity and direct fund. Mother of the petitioner was the assistant mother of.
So, petitioner doesn't have father.
No, my lord, he is also died.
He has also father has also died.
Yes. And my lord, my daughter is young, daughter age is 26.
So what she is claiming?
No, interest of gratuity.
Whether the daughter is the nominee.
Yes, my lord, 32, my lord, 16.
Show me the PPO.
Yes, my lord, page 13.
No, PPO was issued in favor of What is the name of the daughter in the PPO? Yes, Roshni Sharkey. Roshni Sharkey. Mother is Saraswati Sharkey.
Yes.
Where is the name of the daughter in the PPO?
Daughter name Rosmi Party.
Yes. Come to page 13.
Yes, madam.
What is the daughter's name or petitioner's name? It was issued in favor of the late teacher.
My nomination name was daughter name Rosmi Party.
Oh, yes, yes. Death come returned to Roshni Sharkey. Right. Nomination. Yes. Mother died in harness.
Died in 100.
On
13 February 2021.
13 February 21.
3rd February 2020.
Mother died in harness when?
3rd February 2021.
Mother was working in which post?
Assistant teacher of primary.
PPO date?
If you remember, 8 May 2023.
Living interest on gratuity. Yes. Mother of the affidavit of service. Next, mother of the petitioner was a primary teacher who died in harness on 3rd February 2021. Stop. After date of mother of the petitioner by issuing pension payment order dated 8 May 2023, terminal benefits were released in favor of the petitioner, being the daughter. So, petitioner claims interest on delayed. If petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocates. Next. Accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned reserve officer are to pay interest at a rate of 8% per annum to the writ petitioner on gratuity from the date following the date of mother of the petitioner till the date of release of the same, comma, within a period of 8 weeks from the date of communication of this order. Rest two paragraphs. Rest three paragraphs will remain in same. Now, this food. Next.
Item number 15.
I put it this one.
There have been stated by the boss.
It's not the assistant teacher of high school.
He is retired on
Retired on 30 April 2021.
retired on 30th April 2021. PPO,
12 May 2023.
what you are claiming?
Interest of only gratuity.
Issue. Affidavit of service. Next paragraph, petitioner was an assistant teacher of high school who retired on superannuation on 30th April 2021. Stop. After superannuation of the petitioner by issuing pension payment order dated 12 May 2023, material dues were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocates and advocates. Stop. Next paragraph, accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned reserve officer are directed to pay interest at a rate of 8% per annum petition on gratuity from the date following the date of superannuation of the petitioner till the date of release of the set form within a period of 8 weeks from the date of communication of this order. Next.
Item number 16.
Yes,
But petitioner is a Panchayat board member.
full me.
Panchayat board.
Yes,
But return on the 13 November 2020.
30.
Yes,
30 November 2020. PPO
if you are 17 2021.
1712.
Yes, ma'am.
Interest on gratuity.
Yes.
Issue. Average service. Next, petitioner was a panchayat. A petitioner was a Gram Panchayat Kurmi who retired on superannuation on 30th November 2020. So after superannuation of the petitioner by issuing pension payment order dated 17 December 2021. Retired dues were released in favor of the petitioner. The petitioner claims interest on gratuity due to delayed payment. Next paragraph, the respondents are represented by learned advocates. Next paragraph, that accordingly the director of pension provident fund and group pension of the council appeared to pay interest to the market with petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of the same, within a period of 8 weeks from the date of completion of the sum. The rest of the paragraph will be next.
17 for the petitioner. If you can access the
Yes, retired.
petitioner returned on 31st December 2016.
PPO
Last PPO is on 28 December 2016.
20 December. Revised PPO.
Here divided on 2nd December 2022.
First PPO 28 December.
28 December 2016.
28 December 2016. Second PPO. Revised PPO.
2nd December 2022.
Retired when?
Retirement at 31st December 2016. And so far 2019.
Living interest on revised gratuity.
Yes.
Aggregate service. Next paragraph, petitioner was a petitioner was a teacher of a petitioner was an assistant teacher. Petitioner was an assistant teacher who retired on superannuation on 31st December 2016. So after superannuation of the petitioner or on superannuation of the petitioner by issuing pension payment order dated 28 December 2016. Retired dues were released in favor of the petitioner. Stop. Subsequently, there was revision of pay of the petitioner in terms of RUPA 2019 rules. And accordingly, revised pension payment order was issued on 2nd December 2022, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity due to delayed payments. Stop. Next paragraph. State respondents are represented by learned advocates. Next paragraph. Accordingly, the director of pension and provident fund and group insurance and the concerned reserve officer are directed to pay interest on revised gratuity are directed to pay interest to the writ petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of release of the same within a period of 8 weeks from the date of publication of this order. Rest of the paragraphs will go check this. Next, item number 80 is
The assistant teacher of primary.
primary teacher, then retired.
This is the one that died in hand. My petitioner husband was died on.
Petitioner was or petitioner's husband was assistant teacher of primary school.
Petitioner husband.
Say so. Husband was primary teacher.
Yes.
Died in harness.
Yes.
On
21st May 2021.
PPO.
2nd January 2023.
Interest on gratuity. At the agreement service, next petitioner's husband was a primary teacher who died in harness on 21st May 2021. Stop. After date of the husband of the petitioner by issuing pension payment order dated 2nd January 2023. 2nd January 2023, terminal benefits were released in favor of the petitioner being the wife of the deceased teacher. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocates. Next paragraph. Accordingly, Director of Pension Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of death of husband of the petitioner till the date of release of the same, within a period of 8 weeks from the date of communication of this order. Next. Rest of the paragraph. Next. Item number 19.
Yes. During inflation gratuity and area pension under revised report 2005.
9. Primary teacher.
Yes. Assistant teacher only high school.
Retired on
Retired 30th April 2006.
is
And first PPO was issued on 30th June 2006.
is
Revised PPO was issued on 19th August 2010.
19th August 2010.
Revised report.
Petitioner is still alive.
Yes.
You are vigilant enough. After 13 years, you are coming. Very vigilant petitioner. Vigilant petitioner. Petitioner was a agreement service. Next petitioner was petitioner was assistant teacher of high school who retired on superannuation on 30th April 2006. Stop. After superannuation of the petitioner by issuing pension payment order dated 30th June 2006, retired dues were released in favor of the petitioner. Stop. Pay of the petitioner was revised under ROPA 2009 rules, and accordingly, revised pension payment order was issued on 19th August 2010, releasing revised benefits. Petitioner claims interest on revised petitioner claims interest on revised gratuity and area pension.
Yes.
And area pension. Stop. The learned advocate represents the petitioner has opposed the prayer of the petitioner on the ground of delay since revised pension payment order was issued on 19th August 2010, whereas present writ petition has been executed on 3rd July 2023. After 13 years approximately. Therefore, according to the state respondents, the claim of the petitioner is barred by limitation. Next paragraph, in order to give explanation of delay, petitioner has relied upon Judgment of the Apex Court reported in 2008, volume 8, SCC 648, within bracket, Union of India versus Taksin Singh, bracket close. And has submitted that since the issue relates to pensionary benefits and there is no approval of third party interest, the claim of the petitioner may be allowed upon confirmation of bill. Next paragraph. In view of rival submissions made on behalf of the respective parties, this court grants leave to the petitioner to file to make a representation within 4 weeks from date before the Director of Pension Provident Fund and Group Insurance being the respondent number 2 within Director of Pension Provident Fund and Group Insurance being respondent number 2, claiming interest on revised gratuity as per ROPA 2009 rules and ADR pension. Stop. If such representation is made within the aforesaid time, the respondent number 2 is directed to take decision on the representation of the petition on the claim of the petitioner by passing a reasoned order within a period of 12 weeks. Within a period of 12 weeks from the date of receipt of the representation. Stop. Representation. Stop. We are not comma now. If necessary, after granting opportunity of hearing to the petitioner or his representative. So, next paragraph, the decision to be taken by the respondent number 2 shall be communicated to the people within a period of 2 weeks thereafter. Next paragraph, with the aforesaid production, the resources and disposal of there shall be no orders to court. Next.
Yes. This is bank of the petition. Clearing interest and gratuity and area of pension under revised ROPA 2009.
2019.
Yes. Petitioner is the assistant teacher of a high school.
Retired on
31 March 2019.
March.
Last PPO of one issued on the 22nd February 2019. 22nd.
27.
February
27 February 2019. Revised.
PPO was issued on the 6th January 2021.
Claiming interest under ROPA revised gratuity, ROPA 19. Issue.
6th January.
State, yes. Abnormal service. Next petitioner was an assistant teacher of high school who retired on superannuation on 31st March 2019. On superannuation of the petitioner by issuing pension payment order dated 27th February 2019. Retired dues were released in favor of the petitioner. Stop. Subsequently, pay of the petitioner was revised under ROPA rules 2019 or under 2019 ROPA rules, and accordingly revised pension payment order was issued with a memo dated 5th January 2021. Stop. Petitioner claims interest on revised gratuity due to delayed payment. Stop. Next paragraph, paid respondents are represented by learned advocates. Next paragraph. Accordingly, the Director of Pension Provident Fund and Group Insurance and the concerned reserve officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of release of the said amount, within a period of 8 weeks from the date of communication of this order. Stop. Rest of the paragraphs will be mentioned.
21.
Yes. All right.
Yes.
Assistant teacher of a primary school.
What you are claiming?
Revised ROPA 2009. Interest and capital.
Primary school.
Yes.
Retired
31st May 2016.
31st May 2016.
Last PPO was 23rd May 2016.
23rd May 2016. Revised
And
PPO.
revised PPO 15 December 2021.
21. 15 December 21. ROPA 19.
ROPA 9.
Issue petitioner was a primary teacher who retired on superannuation on 31st May 2016. Stop. On superannuation of the petitioner by issuing pension payment order dated 23rd May 2016. Retired dues were released in favor of the petitioner. Stop. Subsequently, pay of the petitioner was revised under ROPA 2019 rules. And accordingly, revised pension payment order was issued on 15 December 2021, releasing revised benefits. Petitioner claims interest on revised gratuity due to delayed payment. Stop. State respondents are represented by unit advocates. Stop. Next paragraph. Accordingly, Director of Pension Provident Fund and Book Insurance and the concerned health officer are directed to pay interest at a rate of 8% per annum to the writ petitioner from revised gratuity as per revised pension payment order from the date pension payment order from 14th February 2020 till the date of release of the revised gratuity, within the period of 8 weeks from the date of publication of this order. Rest of the paragraphs in union saying this was 22. Yes.
And it's been of the primary.
Is retired
30th September 2016.
30th September 2016.
The first PPO was issued on 28th November 2016.
28th November 2016. Revised PPO.
Revised PPO was 22nd March 2021. 22nd
March
2021.
2021.
Yes. Claiming
ROPA 19.
ROPA 19.
Yes, sure. Affidavit of service. Petitioner was a retired primary teacher who retired on superannuation on 30th September 2016. Stop. On superannuation of the petitioner by issuing pension payment order dated 28th November 2016, retirement dues were released in favor of the petitioner. Stop. Next, stop. Subsequently, pay of the petitioner was revised under ROPA 2019 rules, and accordingly, revised pension payment order was issued on 22nd March 2021, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity due to delayed payments. Next paragraph, state respondents are represented by non-advocates. Next paragraph. Accordingly, Director of Pension Provident Fund and Book Insurance and the concerned reserve officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of release of the revised gratuity, within the period of 8 weeks from the date of publication of this order. Rest of the paragraphs will remain same. Before the
23.
Relating to your claiming the area from the date of retirement.
when returned.
Retirement on 31st May 2008, and the petitioner refunded the contribution provision fund on 12 September 2014.
Oh, switching. So pension payment order was issued when?
Issued on 17 March 2016 with effect from
That CPF to GPA.
Yes.
Retired on
Retirement 31st May 2008.
yes. PPO
DPO was issued on 17 March 2016.
17 March. In terms of that memo notification dated 14 June 2014. Now you are claiming retired pension from the date following the date of superannuation. Yes. Yes. Same order. Who is for the state? We can have to reference WP 1116 of 2023, already 5th July 2023. Let us follow. Should it change for retired on 31st May 2008. Pension payment order. Second. 17th March 2016. That is. Hello. This photo.
24.
Teacher of a high school.
Next, retired on
Teacher, 31st January 2018.
2018.
80. First video was issued on 2nd January 2018.
Revised PPO
First video was 17 March 2021.
17th March
21.
2021. Rupa 19 claiming revised gratuity.
Yeah.
Interest on revised gratuity. Issue. State.
Yes, sir.
Affidavit of service. Next petitioner was a retired. Petitioner was an assistant teacher of. Petitioner was an assistant teacher who retired on superannuation on 31st January 2018. Stop on superannuation of the petitioner by issuing pension payment order dated 2nd January 2018. Retired dues were released in favor of the petitioner. Stop. Subsequently, fee of the petitioner was revised in terms of ROPA 2019 rules, and accordingly, revised pension payment order was issued on 17th March 2021, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity due to delay. Next paragraph, state respondents are represented by learned advocates. Next paragraph, accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of release of revised gratuity, within the period of 8 years from the date of communication of this order. This was the paragraph for women's health. This goes up next.
Item number 25. I want the video.
Yes.
There's not any interest of gratuity. It goes at
And primary retired
Retirement 31st October 2022.
PPO
CPO 3rd March 2023.
claiming interest on gratuity.
Yes, ma'am.
Issue. State, you are asking for the state. As affidavit of service. Next, petitioner was a primary teacher who retired on superannuation on 31st October 2022. Stop. After superannuation of the petitioner or on superannuation of the petitioner by issuing pension payment order dated 3rd March 2023. Retirement dues are released in favor of the petitioner. Stop. Petitioner claims interest on revised gratuity. Petitioner claims interest on gratuity due to delay. Stop. Respondents, state respondents are represented by learned advocates. Stop. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned are able to pay interest to the interest rate of 8% per annum to the writ petitioner on revised on to the writ petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of gratuity, comma within a period of 8 weeks from the date of communication of the soil. Rest of the paragraphs will be in same. Dispose of next 26.
Yes, petitioner is the head teacher of the pilot.
In return on
31st January 2016.
revised PPO.
First
PPO.
1st February 2016. 1st February. And revised PPO হলো 8 October
2016. 8 October
2020. Revised
2020.
living interest gratuity under revised proper.
Yes. Affidavit used for the state, you are for the state. Affidavit of service. Next petitioner was a head teacher of primary school who retired on superannuation on 31st January 2016. So after superannuation of the petitioner or on superannuation of the petitioner by issuing pension payment order dated 31st January 2016, withdrawal dues or released in favor of the petition. Subsequently, pay of the petitioner was revised under ROPA 2019 rules. And revised pension payment order dated 8 October 2020 was issued, releasing revised benefits in favor of the petitioner. Petitioner claims interest on revised gratuity. Next, revised gratuity due to delayed payment. Next paragraph, state respondents are represented by learned advocates. Next paragraph, accordingly, Director of Pension, Provident Fund and Booking Clinic and the concerned legal officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of release of revised gratuity within a period of 8 weeks from the date of communication of this order. Next of the paragraph will be mentioned. This was 27.
And what the petitioner?
Yes.
Petitioner side in harness.
Yes. Just a minute. Whether the husband died in harness or wife?
Husband died.
On
My lord, 16 June 2013.
16 June 2013.
Yes, ma'am.
Husband was working in which post?
My lord, assistant to the primary.
Then what happened? PPO?
My lord, PPO is on my lord, 21st November 2014.
2014.
Yes, ma'am.
Yes.
I came only on winter for gratuity.
Rules for the state. Petitioner affidavit of service. Next, petitioner's husband was a primary teacher who died in harness on 16 June 2013. Stop. After death of the husband of the petitioner, on issuing pension payment order dated 21st November 2014, terminal benefits were released in favor of the wife being the petitioner in this writ petition. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocates. Stop. Next paragraph, accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned legal officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of death of the husband of the petitioner till the date of release of gratuity, comma within a period of 8 weeks from the date of communication of this order. Rest of the paragraph will be on this paper. 28. Yes.
This is the assistant teacher of my high school.
Yes. Then
The return on my 30 April 2021. 2021.
30th April.
Yes, ma'am. 2021.
Yes,
My lord, PPO issued on my lord 24 January 2020.
single PPO.
Yes,
24 January,
2022.
claiming interest on gratuity.
Yes.
Next matter, who is applying for the state? Yes, affidavit of service. Next paragraph. After no, petitioner was an assistant teacher who retired on superannuation on 30th April 2021. Stop. After on superannuation of the petitioner by issuing pension payment order dated 24 January 2022, retired dues were released in favor of applicant. Petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocates. Next paragraph, accordingly, Director of Pension, Provident Fund and Booking Service and the concerned reserve are directed to pay interest to the at the rate of 8% per annum to the at the rate of 8% per annum to the petitioner on on gratuity from the date following the date of superannuation of the petitioner till the date of release of the same, within a period of 8 years from the date of communication of the software. Rest of the paragraph should be the same. Let's go to the next.
29.
Yes.
Headmaster of high school. And superannuated on 31st July 2019.
Retired on 31st July 2019.
Yes, my lord. Last week you issued on my lord. 6 January 2020.
Revised PPO.
That will be issued on the same December 2021.
Ropa 19.
Yes,
Issue. Here for the state. Affidavit of service. Next petitioner was headmaster of high school who retired on superannuation on 31st July 2019. Stop. After superannuation of the petitioner by issuing pension payment order dated 6 January 2020. 6 January 2020. Yes, 6 January 2020. Pension payment order now keep sentence to on
Superannuation of the petitioner
by
pension payment order dated 6 January 2020.
retired dues are released in favor of the petitioner. Stop. Subsequently, pay of the petitioner was revised in terms of ROPA 2019 rules, and accordingly, revised pension payment order was issued on 14 December 2021. 14 December 2021. 2021, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity due to delayed payment. Stop. Next paragraph. State respondents are represented by learned advocates. Next paragraph. Accordingly, Director of Pension, Provident Fund and Booking Service and the concerned regulator are claimed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14 February 2020 till the date of disposal of the revised. No, till the date of release of revised gratuity, within a period of 8 years from the date of communication of this order. Rest of the paragraph. Next. Yes.
my petitioner assistant teacher of high school.
Retired on
31st October 2020.
PPO
If you know 10 April 2020.
2023.
Yes, ma'am.
Single PPO.
Yes, ma'am.
Claiming interest on gratuity. State affidavit of service. Stop. Next paragraph. Petitioner was an assistant teacher of high school who retired on superannuation on 31st October 2020. Stop. On superannuation of the petitioner by issuing pension payment order dated 10th April 2023. terminal return benefits are released in favor of the petitioner. So, petitioner claims interest on revised, petitioner claims interest on gratuity between delay and payment. So, this paragraph state respondents are next paragraph. Accordingly, common director of pension, provident fund, and group insurance in the concerned officer are clear to pay interest rate of 8% per annum to the writ petitioner on gratuity from the date following the date of superannuation of the petition till the date of release of the same within a period of 8 weeks from the date of communication of the same. Rest of the paragraphs will be in same this court. Next, T1.
Well, I which way the same thing was happened, my God. This is my what and another same.
I'm saying why there. Item number 31 and item number 97, I don't know 108. The same petitioner for same call.
My God, one for my what dog and another one of Catholic and area.
97 also what?
97 of today's list.
Of today's 31 of today's.
Sounds like
And 108 of today's.
31 is for
What 97? Oh, what?
31 is for overdrawn. Just a minute. Overdrawn. 31 is for refund of excess amount. Then
That's then 97.
97.
Yes, please.
Then 97. Just a minute. Then 97. This is for
That's all for us. Same prayer.
amount is different.
But what is it another challan? Like that is which one is it?
this.
Another.
And then 108.
Just a minute. Then 108.
There is different lordship.
This is for
Discussing of interest, independent. Gratuity and interest.
interest. Do one thing, let these three matters appear tomorrow under the heading to be mentioned. Record amount. At the time of call, learned advocate against 31. At the time of call, learned advocate representing the state respondents has pointed out that same writ petitioner has filed 3 separate writ petitions. One is appearing at serial number 31, comma. Another is appearing at serial number 97, and third one is appearing at serial number 108 of today's first list. Stop. Next paragraph. Let all these 3 petitions appear under the heading to be mentioned tomorrow. I'm coming back after 5 minutes.
There is some more thing in this.
Whether this court has disposed of today,
No lordship, that is very.
very well, you indicate tomorrow. Now other matters will be taken up. I don't want to waste further time.
Lordship, I am here for the petitioner in item number 32.
Yes.
This is the agreement of service, Lordship. Lordship, firstly, I am submitting that there are 4 petitioners and all these petitioners remuneration was fixed by a specific circular issued by respondent number 2, and that circular was violated by respondent number 4. That's why, Lordship, they have filed this petition together, Lordship.
Just a minute.
Lordship.
They are working in which capacity? Petitioners are working under.
They are guest teachers. Prior to that, they were worked as teacher of a government aided school, and they
How long they work?
till the age of retirement. This is
Guest teacher up to which date they work?
up to the age of up to their 65th birthday.
Yes, when 65th birthday was there and when they demitted office.
No, they are still in their office, working as contractual teachers after their retirement. Lordship. They are presently
When they were engaged. But at present, guest teacher is not there.
after the
That
retirement.
school is not there.
No, Lordship. After retirement, they shall continue in their office till the age of 65, Lordship. This is that's why they were appointed.
When they were engaged. Show me any engagement.
Yes, Lordship.
2019 memorandum. Yes.
2019.
That was the memorandum which was violated, Lordship. I am coming to your query, Lordship. Lordship, in page 14, Lordship, this is one appointment.
No, page 23 is the memorandum.
Yes, Lordship. Kindly come to page number 14, Lordship.
Just a minute. Let me understand, because in the case of guest teacher in 2009 and 11 circular, there is a detailed judgment by Justice Radha.
Lordship.
Now, that is whether that judgment is covering this issue or not. That
No,
is
Lordship. This is different.
separate.
Yes, Lordship. Kindly come to page number 14, Lordship.
Just a minute. You are coming under which category? Category 1 or category 2 at page 23?
I am under category 2, Lordship.
Because the unemployed pensioner who retired on or after 1st of January 2016.
Yes, Lordship.
So you are claiming benefit of this memorandum.
Lordship, this has been violated, Lordship. No pay fixation has been issued to me, Lordship, and kindly come to page number 26, Lordship.
So according to you, in terms of this memorandum dated 2nd December 2019, the pay of the petitioners being the guest teachers are required to be revised.
No, Lordship. As per this this memorandum, I am entitled to get my basic pay plus dearness allowance and my house rent, Lordship. And this amount, that is the
So let it be considered by the district inspector of schools.
no, Lordship. District inspector of school
Who is
is
the authority?
SDO, Lordship.
This is a matter regarding police days, you cannot take administrative action because the commissioner of school education will be taking the decision.
But pay fixation order.
So you are claiming the benefit of memorandum dated 2nd December 2019.
But my pay fixation.
But that benefit has not been granted to you.
Moreover,
In
pay
terms
fixation
of
order.
clause 2 of this memorandum, your pay being the guest teacher is required to be revised. That is the basic pay plus dearness allowance as and when admissible from time to time.
Lordship.
Plus house rent allowance if it is house rent is not there.
But they are giving me only my basic. Moreover,
Which was payable prior to promulgation of this memorandum dated 2nd December 2019.
Lordship.
Where is your representative?
Lordship has page number 32, Lordship.
This is to the submission officer, ma'am. What is the
And no
This
pay.
is your chairman, this is chairman, Khasidia Government Model School and Sub-Divisional Officer. No, I will direct the authority director of school education to take this.
Lordship, no pay fixation order.
Whether the direction has been made by
Their homeschool spread is fair as a party.
Commissioner of school education.
Lordship, pay fixation order has not been issued to me till date, but I am working. So,
So let it be decided.
yes, Lordship. That's why I issued my representation to the SDO. And that has.
So you are working as guest teacher in new set of schools at present moment.
At present, Lordship.
This-
After our retirement.
Which petitioners are presently working as guest teacher in same school or different school?
Same school, Lordship.
In the same school, after their superannuation from the post of assistant teacher in high schools. So the grievance which has been voiced on behalf of the petitioners is, in spite of issuance of memorandum dated 2nd December 2019 by the additional chief secretary to the government of West Bengal, finance within bracket audit bracket close department. The benefit which is required to be extended in favor of the petitioners being guest teachers till date has not been extended. Therefore, petitioners are compelled to discharge. Petitioners are compelled to function as guest teachers against the remuneration which has been fixed under the old rate. So, next paragraph, state respondents are represented by learned advocates who has submitted that appropriate authority to take decision with regard to granting benefit of memorandum dated 2nd December 2019 is the director of is the commissioner of, now is commissioner of school education, government of West Bengal. Stop. It has also been submitted that no application / representation has been made to the commissioner of school education, West Bengal. Stop. Next paragraph. Accordingly, the petitioners are granted leave to make a representation to the commissioner of school education, West Bengal within a period of 4 weeks from date, claiming benefit of memorandum dated 2nd December 2019. Stop. If such representation is made within the aforesaid time, the commissioner of school education the commissioner of school education shall take decision on the claim of the petitioners within a period of 12 weeks from the date of communication of this order and pass reasoned order after granting opportunity of hearing to the petitioners or their representative, singular, their representative. Stop. Next paragraph, decision to be taken by the commissioner shall be communicated to the petitioners within 2 weeks thereafter. Next paragraph, with the aforesaid direction, the petitioner
One indulgence.
please hear the with the aforesaid direction, the petition stands disposed of. Next paragraph, however, there shall be no order of as to cost. Next paragraph, the learned advocate for the petitioners is granted leave to amend the cost title of this petition and add Commissioner of School Education, West Bengal as additional respondent in course of this day and course of this day. Stop. Service of office upon the Commissioner of School Education stands dispensed with since state respondents are represented by learned advocates. Stop. The learned advocate for the petition is also directed to communicate the order passed by this court today within 7 days from date. Within 7 days from date. Stop. Next paragraph. Urgent Xerox. Yes. So detailed order is
Detailed order, finding was after 2008, Lopa, no further benefits. 1998. Item number 33.
33 is my matter, my lord.
batch of
33 is my matter, my lord. My lord, here, my lord, it is a small matter under the GST Act, my lord, 2017, my lord. My lord, here the goods were detained by the department, my lord.
who is the petitioner? You are for the petitioner. Yes.
My lord,
Yes.
the goods were detained, my lord, and on payment of the whole penalty, my lord, the goods were released, my lord. Subsequently, being the consignee of the goods, my lord, I had filed an appeal petition, which was rejected by the respondent, my lord, on the grounds, my lord, if your lordship comes down to page number 117, my lord. 126, my lord.
Yes.
My lord, my lord, in the middle, my lord, I have carefully gone through the fact of the case, my lord.
Yes.
My lord, in this regard, I find on perusal of the record that the instant case has been initiated by adjudicating authority by generating this in the name of Vijender Pal Singh, who happens to be the driver, my lord, who was in charge of the conveyance.
Who was in charge of the conveyance?
My lord.
Who was a
And
driver?
My lord, as notice of confiscation MOV 010, my lord, was issued against the temporary ID this.
Just
Since
a
the
minute,
case-
just a minute. Demand the tax and you were the consignor.
My lord, lordship, if lordship comes down to page 100 and section 107
Why
of
you
the
were
GST,
appearing on? Why you were appearing online?
my lord, I could not. I was supposed to come on Tuesday, my lord, but I had this medical emergency, my lord. I had a severe bout of, my lord, food poisoning, my lord. So, my lord, I could not. I missed the train and did not get the ticket, my lord, thereafter.
So goods were released.
My lord, goods were released, my lord. My lord, I went for an appeal. I have come that I, being a consigner, I can also be the party to the appeal, my lord, as per section 107 of the GST Act, my lord.
Show me the section 107.
Lordship, got it, my lord?
No, sorry, just.
My lord, 107(1), the very first line, my lord. Any person aggrieved by any decision or order passed, my lord. The very first line of subsection 1, my lord.
Yes, that's it. Yes, same.
And my lord, I am covered by a judgment of this honorable court, my lord, coordination of this court, my lord, Justice Hiranmay Bhattacharya, my lord. So
Yes.
my junior will be facing that judgment before your lordship, my lord.
Yes.
On the same said matter, my lord.
Justice Kaushik Chandra. Not Hiranmay Bhattacharya.
Yes, ma'am.
Justice Chandra.
Yes.
My lord, my lord, my lord. Page number 2, first paragraph is relevant.
Yes. Yes.
You are let it be decided
By the appellate authority.
Yes.
Only difference is in this case, petitioner was a consignee.
Consignee.
Consignee, you are the consignor.
Consignor, my lord.
Yes, sir. Same proceeding was initiated under section 129 here.
My lord,
Original proceeding.
West Bengal Goods and Service Tax Act
my
27.
lord, my lord. Everything is identical, my lord.
Wait. You have come, though you are appearing online, but you are with all sorts of equipments in order to satisfy the query of the court.
My
In
lord.
view of the order passed by the coordinate bench.
My lord, unfortunately, my lord, I have another matter, but I'll take a leave of your lordship, my lord. And
Yes,
because physically appearing, I am comfortable, my lord.
yes. This is order dated 31st December 2021. No, no. The order of the appellate authority, joint commissioner.
It's similar 31st December 2021.
Yes.
My lord,
It's 23 of the.
Yes. Yes.
page number 123.
123.
In the writ petition, comma, inter alia, comma, Joint Commissioner, State Tax, comma, West Bengal, Siliguri Circle. Now, in the writ petition order passed by Joint Commissioner, State Tax, West Bengal, Siliguri Circle, dated 31st December 2021, whereby the appeal preferred by the writ petitioner, being the consignor, has been rejected, has been dismissed on the ground, being the consignor, comma, being the consignor is under challenge, being the consignor, comma, is under challenge. Stop. The learned advocate representing the petitioner draws attention of this court to the impugned order of the appellate authority dated 31st December 2021, wherefrom it transpires that the appellate authority came to the conclusion that the case was initiated by the adjudicating authority by generating temporary ID in the name of one Sri Vijendra Pal Singh, who was in charge of conveyance, and demand of tax and penalty was raised against Sri Vijendra Pal Singh, being temporary ID holder. Therefore, the petitioner being consignor is not entitled to present this appeal in terms of section 107 of the West Bengal Goods and Service Tax Act 2017. Stop. According to the appellate authority, said Sri Brijendra Singh was the appropriate party who could have preferred appeal under section 107. Stop. Next paragraph. While addressing this court, the learned advocate representing the petitioner has relied upon an order dated 3rd November 2022 passed by a coordinate bench on WPA 927 of 2022 within bracket Mehdi Hassan Rahmatullah Haryani versus Deputy Commissioner of Revenue, Bureau of Investigation within bracket North Bengal close bracket Alipurduar zone and others bracket close. Stop. In Mehendi MEHNDI HASAM. In Mehdi Hassan Supra, the coordinate bench has decided that in view of the provisions as couched under section 107 subsection 1 of the West Bengal of the Central Goods and Service Tax Act.
My lord.
Same provision is there.
West Bengal, this is a proceeding under the WPA.
Under the West Bengal Goods and Service Tax Act 2017. Goods and Service Tax.
In Mehdi Hassan Supra, the coordinator has decided that in view of the provisions as couched under section 107 within bracket subsection 1 of the West Bengal Goods and Services Tax Act 2017. Any person aggrieved by any decision or order passed under the said act may prefer appeal to the appellate authority. Next paragraph. Having seen the provisions as made under section 107 subsection 1, this court concurs the finding of the coordinate bench as contained in the order dated 3rd November 2022. Stop. Therefore, it is found that the finding made by the appellate authority as contained in the order dated 31st December 2021 is not sustainable in view of section 107 subsection 1 of the said Act of 2017. Therefore, the same stands. Therefore, the order of the appellate authority dated 31st December 2021 stands set aside. So, next paragraph. The appellate authority shall hear the appeal preferred by the petitioner being the consigner in accordance with law and dispose of the same within a period of 3 months from the date of communication of this order. Stop. Next paragraph. Accordingly, the petitioner has disposed of, there shall be no order for cartridge.
A small indulgence, my lord, 1 month, my lord.
No. To that extent, I am not concurring with the view of the coordinate bench. Very well. 2 months. Let it be 2 months.
My lord, my lord, my lord.
2 months. 2 months. 2 months to baad 8 weeks. 8 weeks.
My lord,
Number 34.
Yes, please go down. I am keeping this order of the coordinate bench. Yes. Who is appealing for the petition now?
Well, I think our commissioner, which one are carrying for the due to the
Where will let it be before the next circuit?
now.
What is the weakness of this petition? That's why you are not willing to do the matter within the scope.
Yeah. Only my plan.
Very well. At the time of call, accommodation has been paid for here with the petitioner. Petitioner. Stop. Next paragraph, let the matter be listed under the same heading. Let the matter be listed under the same heading before the next circuit, subject to convenience. Next, 35. Yes. Yes, yes. You are appealing for? You are appealing for which? Oh, file an application for addition of party.
I am working because the land which is in subject matter of this petition, I am also a co-owner or co-sharer of this of the land. I have served the.
What is the prayer in the writ petition? Let me see.
When this small fact to it, we do not have an objection with them being added as the part. That's fair enough. They have some bit of because one of the prayer is
Yeah, that's it.
can I deal with the repeats for a moment?
Just a minute. Let me go to the prayer first. So what you are claiming?
Well, what happens is, similar to our hearing already yesterday. What has happened? There is a land, a plot of land in the national highway somewhere in Siliguri. What happens is, my God, this land, this is the vacant land, free, unencumbered, recorded in land. We have annexed
Recorded
in our name. We have annexed the LR report, LR report here and the reports.
I recorded in the previous name of the
It was in the name of the petitioner, subsequently recorded in the writ petitioner, same that is here next to the writ petitioner. My lord, the next P2 P2. And what happens is, my lord, and placard and army signboard is placed for early. My lord, we send a notice. We send a notice whether this land is required with an army for acquisition or not. If it is required for an acquisition, we file an. There is no section 4 proceeding, no section 6 proceeding. If there is an acquisition proceeding, or if there is a proposal for acquisition, kindly say it. That's the notice precisely. Kindly reply to us. That's the notice precisely that we have sent. Now there is no reply that comes. Afterward, what we do, since there is no reply sent by the army, we come before the court. Now the court hears it on the first cases, ask for an affidavit to be filed by the center, by the union, that whether the land is required for acquisition or not. Now an interim order to an effect will also pass. Subject not to dispose the petitioners with due process of law. Now we are not on board. We don't need an interim order also to that effect with it.
Because due to influx of time, you have understood that you are not going to be dispossessed.
Disposed sooner.
Yes.
No, that was not required also. An affidavit was definitely required. 8 months since there is no affidavit.
There is a direction for filing affidavit.
There is a direction.
That is why this is appearing under the heading motion.
But since a CAN application probably has been filed, that's the reason.
In the interim period, the Union of India reported an appeal against the order that's the files. However, the appeal for disposal of 6 We will file our affidavit, but before that,
What was the order passed by the appellate court?
we will do it, because the extension order passed by this court was not extended any further. They died a natural death. So we had no reason to pursue that appeal. Well, now,
No, whether you are going to take this land, that is the moot question.
that is moot. My lord, before that, it is not title.
No, certainly not.
Because my lord,
Mr. Majumdar, certainly not.
my lord,
Clear your stand before this court that whether you are going to take the land or not.
we will file affidavit, my lord. But
No. Please, court wants to hear it from you. Don't make tacit submission before
my
this court.
lord, there is a dispute in the entire land.
Maybe, but whether you are going to take the land or not.
We will demonstrate before this honorable court with documents and with papers that there is no land belong that we are occupying, as they say. We don't need to acquire any land of yours. Whatever land was there.
Let me record this order that it has been submitted by the additional by the agency for the proposition that they are not going to take the land of the citizens.
No, my lord. I need to file an affidavit. I will disclose everything in the affidavit. Lordship, on this plot of land, there were several litigations. Whatever land was acquired from the predecessor in interest.
Don't lay your ears to your junior.
This plot of land is litigated since 1930.
Answer. That's. So there is a direction for filing affidavit. So let the affidavit be filed and your application may be allowed.
I also no problem.
You file your affidavit disclosing whether the respondent authorities are going to acquire the land or not.
But you will disclose everything. Entire history of the land.
Can I just answer? Because since this putting aspersion of civil suit, the interland.
Yeah, the court is not considering this.
But
Yeah, Mr. Majumdar in all land matters takes this point. That is a civil suit.
oh my God, only one the first
It's a matter relating to civil dispute. But this is the first land matter you are doing before this court.
So I didn't take this brief, my lord. But my lord, I will be able to demonstrate before the lordship that this is a dispute.
Where is your application for addition of party?
Can do.
Can do is not, can one is there, but can two is not before this court.
in the list,
It is in the list, but the application is not on record. Can two is not on record. Mr. Gaur.
well, can I just
Before affidavit, what is the use? Because court cannot decide on without affidavit.
I'm not telling you everything. I'm only at page 55. What I was
The writ petition is taken up for consideration in presence of the learned advocates representing the petitioners and Union of India. Represent the petitioners and respondent authorities. You are appearing on behalf of all the respondents and the respondent authorities. So, on to next paragraph, Mr. Majumdar, Mr. Sudipto Majumdar, learned Deputy Solicitor General, has submitted that against an interim order passed by the coordinate bench on 2nd January 2023. And in fact, appeal was preferred before the Honorable Division Bench. And the same stood disposed of without passing any order interfering with the interim order passed by the coordinate bench in view of the fact that the interim order expired prior to consideration of the intra-court appeal by the Honorable Division Bench. Stop. Today, on behalf of the respondents, it has been submitted that that the respondent authorities are willing to file affidavit in opposition in terms of the order passed by the affidavit in opposition in terms of the order passed by coordinate bench on 11th November 2022. So let the affidavit in opposition be filed within 2 weeks from date. Reply there, affidavit in reply thereto, if any, be filed within 1 week thereafter. So parties shall get liberty to mention the matter before the next available circuit. After the time fixed herein above for exchanging affidavit. Stop. Next paragraph. Mr. Devoshi Dhar, learned advocate, submits that one application has been taken up, being can 2 of 2023, seeking addition of can 2 of 2023 for addition of party. Can 2 of 2023 wherein prayer has been made by the applicants, one or more than one applicant, by the applicants to be added as party respondent, party respondents. Next, next paragraph. However, on perusal of records, it appears that a said application is not available on records today. Stop. Next paragraph. Department is directed to make the said application available on record on the adjourned date. Stop. Let the matter appear. Let the application being can 2 of 2023 appear before the second day of next circuit, subject to consideration, subject to convenience. Yes.
Can I ask submission
let them file their affidavit. You will file your reply, then it is to be heard.
only with regard to
Today, this court cannot pass any further order.
I'm not seeking.
So why you are making the submission?
Order. And I'm not seeking for an interim order.
Yes, then why you are making this?
But in spite of there being an interim order, I was not pressing on it.
Yes, that you have made it clear.
What I had said, my lord. What, my lord, and
Yes.
page 50 from page 55, my lord, my record of rights, current LR record to right. And I have a subsisting right on the land as well. My lord, to make submissions that there is a title suit, there is title suit, so what? An army authority
Court has not accepted this submission. That's why court has directed the union or the respondents to file a
Prefer the oral file rather than documented.
Yes, next matter.
And it is number 36.
very much.
My lord, 36, I am appearing, my lord. My lord, identical to the matter, my lord, and 33, my lord. Only the date of appeal will be changing, my lord.
33.
My lord, 33, my lord.
Only date of order of the appellate
Appellate
authority.
authority. My lord, 31st 12 2021, my lord. In that place, it will be 03/01/22.
Which page?
My lord, page number 127.
Just a minute.
My lord.
127.
My lord.
You are the consignor.
My lord. Well, here also the driver is Vijender Pal Singh, my lord. Temporary ID generated in the name of the driver.
Page 127. What is the name of the driver?
My lord, Vijender Pal Singh, my lord, in caption it is written, my lord, temporary ID this generated in the name of the driver, person in charge of the vehicle, Sri Vijender Pal Singh.
Same driver.
My lord, same driver.
And
Same vehicle, same driver, my lord.
it is also an appeal of consignor.
My lord.
Same order. Same order. Only date of the order of the appellate authority is different.
My lord.
Yeah, the date is 3rd January 20. It is not readable.
2022.
23rd January 2022.
My lord.
3rd of January 2020.
Yes, 3rd January 2022.
ওটা কোন যেটা নভেম্বরটা যেটা ওই ইয়ে
আমি যেটা বললো যেখানে থেকে appellate authorities order যেটা
নভেম্বরে ডিসেম্বর টোটাল
instead of 31st December, 3rd January 2022. Same order.
My lord, grateful lordship.
Item number 37. Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. So, next paragraph, it appears that on 4th July 2023, on the prayer of the non advocate representing the petitioner, matter was adjourned and today matter has been fixed for hearing. Stop. Next paragraph, it appears petitioner has lost the interest. Stop. Writ petition stands dismissed on the ground of writ petition stands dismissed on the ground of default. Stop. Yes, at the line at Purada, state respondents are represented by learned advocates. Next.
38, appears on the petition. Last location where there was the direction for service, which is from the record. I felt on the there was certainly question if the law that is in the last order. Prior to that order also there was direction for service which we have served, but the state respondents are being served as private respondents.
Yes, what is the matter of it?
On behalf of the private respondent, in Chennai, my clients came to yesterday received and telephonic instruction have not received the Calcutta and copy of the petition. Kindly action the matter. My handle service.
What is the matter of it?
Matter about I am sending the order passed by the appellate authority under the maintenance of welfare parents.
Under
the maintenance and welfare of parents and senior citizens Act 2007. But we prepared an application alleging that my son is not maintaining me. That was dismissed. We prepared an application. Your lordship guidance is the page 65.
You are appealing for some.
Yes, ma'am. Well, by its order, which I am
Paid for cancellation of fees.
cancellation of deeds and also by that from
What was the order passed by the appellate authority?
appellate authority, my lord, without hearing, my lord, in a mechanical manner, your lordship can be seen, just rejected by application, says that is not completed.
Where is the order?
Well, order is that page 63. So if the rule says there must be a hearing, he must be given an opportunity, we must give up. Rules.
Mother is the
Mother is there.
Complete payment, demanded back for further costs, but they are not representing to you. How court will dispose it also. They logically see the order, but and he is praying, my friend is praying for time. Last occasion, nobody appeared. The service was not complete. The service was complete. My friend could not service because I had given a composite. Let a chance be given to him. For the first time, you are appearing this. Why you are misbehaving with your mother?
Instruction, I'm not only the
An old lady? Yes.
I'm taking instructions, specific instructions.
Staying at Chennai. Why you are doing this?
For medical purpose.
Let me set aside the order of the appellate authority and remand the matter to the appellate authority for fresh consideration. How an appellate authority pass an order without hearing the old person?
Instruction can be at one matter.
At the time of call, petitioners are represented by petitioner is represented by learned advocates. Stop. However, the learned advocate representing the respondent number 4 has prayed for accommodation to obtain instructions and file vocalatma. And obtain instruction and file vocalatma since he has been engaged on behalf of the respondent number 4 recently. Yes. Next paragraph. In view of the prayer made on behalf of the respondent number 4, list the matter for further consideration on the second day of next circuit, subject to confidence. In the meantime, the learned advocate representing the respondent number 4 shall take necessary steps and file vocalatma in the department. Affidavit, next paragraph, affidavit of service filed on behalf of the petitioner is taken out. Next. Oh, you are for the state respondent, read your affidavit. 59. Yes.
The petitioner was an is joint position of land in Jalpaiguri order. And thereafter the petitioner along with his co-sharer sold the land in 3 parts to 3 or more merchants. And at the time of executing of the sale deed, on good faith, he executed the deeds and did not receive the full consideration amount of the land. And thereafter, it's the petitioner sent.
Who are respondent number 2, 3, and 4? Let me see.
Respondent number 2 is the continuity of portion.
Against which incident you are seeking investigation?
At the time of executing the deeds, the petitioner did not.
Who were the executor of the deed?
The petitioner.
He was the seller.
Yes. He did not receive the full consideration amount. On good faith, he signed the document. And later on, he sent a notice to each and every purchaser that he did not receive the amount of consideration amount. They received the notice and they did not reply. After that,
The file is put against the petition, against the purchases. How this can be brought to the field of criminal law?
but criminal breach of trust.
You have sold out a land to some persons and the deed has been executed. You have signed the conveyance deed and subsequently it is presumed that on receipt of the consideration money, you have signed the deed or conveyance deed. So where is the scope of criminal liability so far the purchaser are concerned?
For that purpose, the petitioner.
And where is the criminal breach of trust? Where is the scope of criminal breach of initiating a proceedings on the allegation of criminal breach of trust?
On the request of the petitioner, the petitioner signed the document and they are known to each other. They were known to each other and they told that they will pay after some time. So on the basis of their.
For that, it's a civil consequences are there. How a criminal investigation can be directed by this court by issuing a writ of mandamus? Satisfy the query of the court. You are the seller. Conveyance deed has been executed. You put signature on the conveyance deed. Then it is presumed that in receipt of consideration money, you have signed the conveyance deed and you have executed the conveyance deed in favor of the purchasers. Now, you subsequently, when this deed was executed, on which date?
In the year 2013.
2013.
Yes.
And today you are filing a writ petition.
But the notice of the to the purchaser in 2020. Phone call was made between the purchaser and seller.
Where you have stated that the conveyance deed was executed on 2013
In petition.
in the writ petition.
Yes. In paragraph number 4.
It is.
Actually, this is one thing which that get to instigate by the use of it understanding by the court is not
When?
much after filings because actually the year 2020 this petitioner sent a letter to the OC Pantine Lordship, but that time they are not identified the PO. So later on, they discussed with the then they call the counter this petitioner after filing the litigation, and they identified the what and also PO. After that, the petitioner is
Let the criminal investigation and proceedings continue. This court will not interfere with the steps taken by the police authorities. But no mandamus can be issued on this.
I also handed over the copy of paper.
Not required. Writ petitioner has complained of non-payment of consideration money to him while executing a deed of conveyance in favor of the purchaser in the year 2013. Petitioner has paid for initiation of proceedings and investigation by the concerned police authorities for non-payment of consideration. Next paragraph, on perusal of the writ petition, it appears, it transpires that petitioner has sold out the property along with other co-sharers, but co-sharers have not come forward with the same plea. Stop. Even the date of execution of deed of conveyance has not been indicated in the writ petition. Next paragraph. This court fails to understand that if consideration money was not paid to the petitioner, why the conveyance deed was executed by putting signature by the petitioner in 2013 and 2013. Stop. After, stop. If this court proceeds on the premise that conveyance deed was executed in 2013, then why contemporaneously steps were not taken by the petitioner? Stop. The present writ petition has been instituted on 19 June 2023 with the allegation that purchaser did not pay the consideration money after execution of conveyance deed in 2013. Stop. Next paragraph, it is a settled proposition of law that there is no limitation in the matter in filing the writ petition in respect of a cause of action, but the ordinary period is 3 years. Stop. Here, petitioner has approached this court approximately after 10 years. Stop. Next paragraph. In view of aforesaid scenario, this court does not find any merit in the writ petition and the same stands dismissed. However, there shall be no orders to court. Next. Evidence service filed on behalf of the petition is taken on record.
Item number 40.
In this case,
Can matter.
Lordship,
Yes. Very well, comment.
They've been stayed by the.
I have the. Lordship, so currently it's next subject.
Which order has been stayed by the Supreme Court? That primary the division bench order was appealed against the Supreme Court.
The division bench state partially only allowing the recruitment process to go on, the fresh recruitment process. Now the Supreme Court has said that portion also. Whole.
Now, what is being claimed in this writ petition?
Now, like this, in this writ petition.
At the time of their appointment, they are under training process. And the primary court was not taking into consideration that they are the trained candidates. So we get rid of the criteria for incident, we have challenged.
Is a 2017 selection process. 16. 2016 selection process. So you are claiming appointment.
No, we already appointed, but as a trade category, they did not consider as a trade category. There is a cross.
You are not in position to place the case properly.
There is a cross number 6 where it has been stated that at the time of the recruitment process, they have to consider as a trade candidate because we have already started our training process.
So where you appointed? Whether you are appointed?
My training was completed, but
Where you are appointed?
Lordship,
In the post of primary teacher
Lordship,
as an untrained candidate,
Lordship,
not as a trained candidate.
Lordship.
Now you
My
are
training was
you are
completed.
claiming that you should be treated as a trained candidate.
Lordship.
So how this issue can be clubbed with that issue?
What happened? The Justice Gangothar's order was that the entire trained teacher and untrained teacher, their services have been struck. The
Struck off only the untrained.
untrained category. The moment the petitioner's case is that, when there was an appointment, they were
So they were untrained candidate.
untrained candidates, they were pursuing the course of the DLED course.
So now they are coming to the side of trained category,
Yes,
so that their service cannot be
yes,
interfered
yes, ma'am. So
by
that's
the
why,
order passed by Justice Gangotha.
that's why, unless it has been decided, my lord, there, because if it is decided,
The precise claim is that on the date of recruitment, the entire process was.
The writ petition is taken up for consideration in presence of the learned advocates representing the petitioner and West Bengal representing the petitioners, West Bengal Board of Primary Education and the state respondents. Stop. Next paragraph, the learned advocate representing the West Bengal Board of Primary Education and the state respondents have jointly submitted that the issue cannot be decided at this stage in view of pendency of the whether the leave granted
Lordship.
or on it has been stayed. It has been stayed on.
when the order,
In view of the pendency of the appeal before the Honorable Supreme Court, which was preferred against the order of the Honorable Division Bench of this court, the issue involved in this writ petition cannot be decided. Representing
the West Bengal Board of Primary Education and the state respondents have jointly submitted that the issue cannot be decided at this stage in view of pendency of the appeal before the Supreme Court.
In view of pendency of appeal before the Supreme Court,
This is by the Supreme Court, that is valid by the division bench.
for reconsideration.
Reconsideration, Lordship.
So in view, where is the order?
Lordship.
to be decided afresh by the division bench.
Yes.
And now actually said it.
I'm keeping this.
The learned member representing the original board of primary education and the state respondents have jointly submitted that the issue involved cannot be decided at this
The
stage.
issue involved in this petition cannot be decided at this stage.
It cannot be decided at this stage in view of pendency of
Now, in view of the order passed by the Honorable Supreme Court dated Honorable Supreme Court of 7 July 2023. On a special leave petition. On a special leave to appeal. Within bracket C, bracket close, number 13024-13026 of 2023, within bracket Tuhin Kumar Haldi and others versus Priyanka Noskor and others. Stop. With the order dated 7 July 2023, the issue has been remanded, the issue relating to the selection of selection and appointment of primary teachers from the panel prepared in the year 2016 was remanded to the Honorable Division Bench of this court for taking final decision. Stop. Next paragraph. In view of the order passed by the Honorable Division Bench dated 7 July 2023, let this writ petition go out of list with liberty to mention the matter.
in view of order passed by the Honorable Division Bench.
In view of the order passed by the Honorable Supreme Court,
It is 7
July 2023, let the matter go out of list with a leave to mention the matter after the issue is decided by the Honorable Division Bench.
Items 41, 42, and 43 are in the manufacturing.
Up to 43. Up to 43.
Lordship.
Yes.
In 41, I'm afraid one.
Ladies, let us know.
Same on.
নাম বলুন দিল
এটা রেখে দাও, এটা ওর সঙ্গে দিয়ে দাও। 43 Yes, for the list. Mayor Lordship. With that. One matter it was mentioned by physical interview and the Lordship, the report was directed to be filed by the city. It is a pencil matter of the civil. So it has been filed, the report has been filed. Today, appealing 128 can be taken out. I have refused same prayer to others. Mr. Vice. No chance. No chance. No, if it is normally reached, it is called down. Similarly, if it is called down.
No, I have rejected your lordship rejected the matter to appear.
I have directed all the matters to appear apart from the mentioning.
No,
There is a pressure for this bench is conduct. Try to appreciate our predicament. It's Mr. Badu. Please don't mention, don't embarrass this book. 44. Why?
Well, actually, this is a matter which should go to the tribunals. Everyone land.
Yes, sir.
Challenge from the order of path by the district land and land.
Whatever the other a civil court judgment was placed in front of him, totally bypassing the civil court degree, because in my memory, the BLRO Act.
So you are praying for correction of record of rights pertaining to arrest plot number 456, renumbered 642, subsequent to Ila survey, Manga, Financial District. So it's a correction for of record of rights. Yes. Now, which order you have challenged?
Order of the appellate authority at which
That's the link. That's the link.
connection.
Third January 2018 order of the district land and land development officer. Which page?
Page 63. Page 63. Page 63 bottom is the order. The 3rd of January 2018. This was passed under section 54 of the West Bengal Land Reforms Act.
Appeal provision.
Second appeal line before the land reforms and the strategy.
Yes, sure.
No, Lordship, may I?
Sorry.
Lordship, may I?
Yes.
Lordship, there are instances where the bar of alternative remedy would come in the way, Lordship. Because my Lordship, a civil was that it was.
Yes, the petition is taken up for consideration in presence of the learned advocates representing the petitioners and the state respondents. So, at the time of call, the learned advocate state respondents. So, next paragraph. On perusal of records, it appears that the petitioners has challenged the order of the appellate authority under section 54 of the West Bengal Land Reforms Act 1955 and the Deputy District Land and Land Reform Officer Alipurduar, and consequently and also prayed for correction of record of rights.
Deputy District Land
No, what is it? And Deputy District Land and Land Reforms Officer Alipurduar, and has also prayed for correction of record of rights. Pertaining to some pertaining to plots of land as described in the written petition. So next paragraph, considering the issue involved in this written petition and the order passed and the impugned order dated 3rd January 2018, passed by the appellate authority, it appears that writ petition, it appears that present writ petition is not maintainable. Stop. According, it's not maintainable. However, appropriate remedy lies before the West Bengal Land Reforms and Tenancy Tribunal. Next paragraph. In view of aforesaid position, the writ petition stands dismissed. However, this order shall not preclude the writ petitioner to take necessary steps in accordance with law, challenging the order dated 3rd January 2018, passed by the appellate authority. Next paragraph. There shall be no orders to court. Next. Unnecessarily keeping this matter pending, well, you are wasting your own time.
Lord, 45, I beg to appear on behalf of the respondent of 5. My video is off from your lordship saying lordship. Lord, I beg to appear for respondent number 5. I am appearing virtually, but my video is somehow locked from your lordship saying.
Allow visual.
It is showing that you cannot start video because the host has disabled it.
Yes, what is the matter about? Pertaining to RTI. What information you are seeking?
Land was acquired by the respondent authority.
Who is representing the respondent number 3?
Quality, and we have supplied petition of the queries. I have not stated no.
Where is your application under section 6?
First application answer P1 is 12A.
12A.
Yes. Thereafter, the responsibility replace the same and the supply related to case number and project name loaded.
Just a minute. Whether the land has been acquired, if it is acquired, the LA case, and if the compensation has been paid, then LAP case. Number and details have been
But petitioner has also supplied to.
These informations have been information has been just a minute. Just a
My
minute.
data 3rd February 2020.
3rd February 2020.
23.
Page.
These are.
Show me.
They are written for
What is the 12th July letter by which it has been informed? Mr. Yes, 12 July, 2022. That. Yes, come to your 21st July 2022 letter, State Public Information and Special Land Acquisition Officer, Jalpaiguri. What is stated there, that you are requested to supply either the LA case number or project with Mousa name for which the land has been acquired, so as to supply him relevant information.
By another letter dated 6 June 2023, we are informed that the project name was informed to them along with the plot of lands.
Informed by the petitioner.
Informed by the informed to the petitioner.
By which letter?
6 June 2020.
Whether you have copy of this letter? June 2022.
23.
Yes.
Involved the spelling contribution and its relevant process.
Yes, information has been provided to you.
No, sir, I have not received any information. Kindly see the.
No, but come to page 12. Come to page 12A of the writ petition. No, yes. Wait. That is to 16 December 2019.
Thereafter, long time back, I have faced application before the respondent number.
When is that?
P2 is 80. Then application.
Page 18.
Is 80.
Same application.
Yes,
Very well. Then, please wait. First, there was an application. But the RS plot number, which has been indicated in memo dated 6 June 2023, which is not tallying with your application at page 12, capital 12A. At page 12B, annexure P1. They have indicated RS plot number 49, 61, 62, 138, 50, and 137.
Yes.
But you have indicated 7, 8, 49 by 166, 49 by 464. So that is not telling to
Not a.
show this document to him. Show this document to him. Dated 6 June 2023. It is not telling with the RS plot number which you have stated in your application dated 16 December 2019.
That is not it.
Then
But the instruction that we have received from the Gazette notification will be in the second page of the Gazette notification. That's the photo like it.
where
There is the problem of submission. In the second page, land sheet.
second page of
The Gazette on this instruction. Second page of the Gazette notification. Which is annexed to the instruction.
find it out. Yes.
Just the first stage. And the second page of the Gazette notification was land schedule. Well, that would tell you with the information sought by the manager.
Yes, 49 by 166.
What happened?
Then 49 by 160, 464. Then you supply information.
No.
You supply information based on this letter under RTI
Section somebody copy of this. That would solve.
Yes.
If this instruction is and a copy of this is and that would solve.
No, I will direct the authority to supply information based on this. So writ petition is presented, comma, inter alia. Writ petition is presented, comma, inter alia, comma, praying for supply of information based on the application made by the petitioner under section 6 of the Right to Information Act 2005, dated 16 December 2019. So such application dated 16 December 2019 was addressed to the State Public Information Officer, comma, Special Land Acquisition Officer, comma, Collectorate Avenue, Jalpaiguri. Stop. Now, State Public Information Officer, comma, Special Land Acquisition Officer. State Public Information Officer, comma, Special Land Acquisition Officer. Stop. On perusal of the application and the application made under Right to Information Act, it appears that petitioner has sought for certain informations with regard information whether the land, the plots of land as described in the said application has been acquired under the relevant statute or not, and if acquired, the consequential steps taken by the authority. Now, if acquired, the details of consequential steps taken by the authority that is LA case number as well as acquisition proceedings.
LP number 20 or 2020.
And LAP case number and date. LAP case number and date. Stop. Next paragraph, the learned advocate representing the state respondent submits that previously information was provided by the state public information was provided by the Special Land Acquisition Officer, Jalpaiguri, video memo dated 6 June 2023 to the petitioner. However, there is no specific response with regard to the application dated 16 December 2019 as made by the petitioner under the Right to Information Act. Stop. Next paragraph. Accordingly, special land acquisition officer, Jalpaiguri, being the respondent number 3, is directed to give provide information to the petitioner based on application made by the petitioner under Right to Information Act dated 16 December 2019, which is at page 12A, annexure P1 to this writ petition within 3 weeks from the date of communication. Stop. Next paragraph. With the aforesaid direction, the writ petition stands disposed of. Take it back. Next. Item number 46. Yes. Is it a group 9 matter?
No, you lost it.
Yes.
Yes, group time.
But there was a direction by this court to amend the presentation.
Yes, Lord.
Actually, what amendment was required?
According to us, Your Lordship, no amendment is required. Actually, Your Lordship, it's not a land related matter, Your Lordship.
What you have for the response? Yes, what you are praying for?
Your Lordship, in the deed of convenience dated 31st January 2022.
Yes.
Erroneously entered second floor in place of first floor.
Second
floor in place of first floor.
So for that, a deed of declaration or deed of correction is
rectification. Your Lordship, we appeared before the ADSR, Siliguri, and we submit our representation dated 20 April 2000.
What representation? You present a deed of correction.
I placed before the ADSR, Siliguri, but they simply reject. They simply deny. We will not execute the deed of declaration. Later on, we place our representation dated 20.
Have you obtained any instruction in this matter?
Already they have filed a title suit for acquisition of the before the immediate junior university. Yes, sir.
It's not. It's already withdrawn.
Where is the withdrawal order?
There is not a mentioned.
Later, earlier it's a withdrawal. Thereafter, you Lordship, we file the suit. We already withdraw.
Where is the order of withdrawal? Seeking for a declaration.
Yes, Lord.
For rectification of deed. But if there is a defect in the deed of conveyance of deed, a deed of rectification or clarification is required to be presented before the registering authority.
Or for their entire property is going to be changed. Valuation, they have to pay separate stamp duty and.
Lord, if any kind of valuation, different valuation, I am ready to pay, Your Lordship.
Where is your order of withdrawal? Issue. The writ petition is taken up for consideration in presence of the learned advocates representing the petitioners and the state respondents. The state, next paragraph, the learned advocate representing the state respondents has opposed the prayer of the petitioner on the score that petitioners have instituted a suit seeking declaration subject matter of the suit is touching upon the issue involved in this writ petition as submitted on behalf of the state respondents. Next paragraph, the learned advocate representing the petitioners submits that that the suit has been withdrawn. However, the order passed by the civil court, wherefrom it can be ascertained that the suit has been withdrawn, is not placed before this court, and the learned advocate representing the petitioners has prayed for accommodation to produce the order of the civil court. Stop. Next paragraph. In view of aforesaid facts, leave is granted to the petitioners to file a supplementary affidavit enclosing the plain and the order passed by the civil court on the same suit. Let such supplementary affidavit be filed within 1 week from date, with an advance copy upon the learned advocate representing the state respondents. Stop. Next paragraph lists the matter before the next circuit subject to convenience for further clarification. Next.
7. Item number 7.
After the
Appearance readable provide. Officer, my application, but you have only agreed to here 134. Then that is make it 134 for this.
Otherwise, you will be in soup. At the time of call, let the matter appear before the next circuit for further consideration. Next, 48. Because this issue is covered by the order which has already been filed, that order which has been passed by this state. Very. Yes.
Okay, time
Yes. Yes.
Retired from the service. I was 2022. I was allowed.
You retired from service on
31st May 2022.
From which post?
And then he said, charge. Actually, lots of
Retired in the post. 31st May 2022.
But I was honored candidates. Appointed in 1992 and 96, I completed postgraduate degree in the relevant subject of in history, and I was allowed to enjoy postgraduate.
You are originally a honors candidate. You are originally a teacher of which group?
Social science. Yes, my history social science college, and I completed my postgraduate degree in the year of 1996, and my 1997, from 13 June 1997, I was allowed to enjoy postgraduate scholarship.
Yes.
Now, I could not complete your time in public manner. There was no occasion to get admission in the BEd. That BEd course, I retired without. To show my incremental benefit, some incremental benefit was allowed up to 5 years, thereafter 10 years. Now in the objection, they have
Incremental benefits due to BH qualification.
now that after retirement or prior to retirement shortly, before much before 1 year, there was a demand of recovery of that post benefits of pay as well as income.
When this demand was made?
And that this demand was made. And it appears that memo was issued on 20th April 2020.
For recovery. Where is that memo?
Page 30. And later of the school authorities page 31.
Who is appearing for the school authority?
School authorities are the receipt.
Service completed.
The state is the real
Contesting of the process. 11 July. Yes. Where is the recovery order?
The notice of the school authority page 31 is the process. Yes, sir. This is on 15th June 2023.
Just a minute. Incremental benefits for BH qualification as well as initial pay in the higher and higher scale as per Geo 33 EDNB. That is Rupa. That is 1990. Rupa. But I couldn't follow the contents of this.
Actually,
Tried to understand, but I couldn't.
I was right to lots of time that is 31. The demanding excess amount from 1690 31 May 2020.
Where from you are getting this?
This is the page 31. Page 31 last question. Show according to account section. You are refund the excess amount from 1690 to total overdrawn of rupees 11 lakhs for clearing your question. The teacher is eligible for higher scale. As teacher enjoyed initial pay and higher scale as per Geo number 36. So please listening for Geo should be.
When this objection was raised, observation was made by the pensioner. This is the communication of the school, but when the
This, in the Joint Director of Accounts, page 30, the memo was issued on 24/2022, and initially it starts from 7/6/2022.
7/6,
2022, page 28, it is also signed.
7 June 2022.
2022.
Where the observation has been made in this memo, in this document, which starts from page 28.
Only document this page 30. Non-trained teacher continued trial and
Page 30,
page 30.
where
Where the right hand portion.
we on 1st of July.
As a non-trained teacher continuing in drawing annual increment which is not eligible as per Open Entry 90 order 16 4, therefore pay is to be recasted and overdrawn is to be recovered. This was the.
This is dated.
This is memo 20th April 2020. The memo number as I find. And memo number also keep made in 2020. What? Before that, when the other two documents.
This is memo date 20th April 2022.
20, one of the 20th April 2020.
Or 5th May 2022.
May 2022, both memos are there. And before
Issued by which authority?
as this is the authority when they pointed out that the school authority pointed out Joint Director of Accounts. And it starts from page 28. It also appears from 7/2/2020.
Joint Director of Accounts attached to the office of the district inspector.
Every district inspector is for Joint Director of Accounts.
Yes, how it is permissible in view of the law laid down by the Supreme Court.
Comrade, I would like to comment on evidence because as it appears from page 28, initial from initial section of pay million, he was already drawing the benefits of had tested.
Should I hand over the judgment of movement also? And relying on what's it that
Yes.
well, other coordinating bench also delivered that.
I'm not denying that the law laid down.
They pay, he should not die, to not any. And Thomas Daniel also.
I have delivered arguments. It is the principle. Now, one thing which you can do, the recovery to the extent of 11,16,754 is not permissible. But that petitioner will not be petitioner will not be required to refund. But while fixing the pension, you are at liberty to fix the pay of the petitioner for payment of pension. Recovery not permissible. Law laid down by the Supreme Court. Our High Court has passed an order. I have delivered a judgment. So therefore, the recovery is not permissible after such a long period of time, because it's from 1st of June 1998 to 31st of May 2022. After a long period of time, at a time of retirement, that is impermissible. But the pension sanctioning authorities shall be at liberty to fix the pay of the petitioner in accordance with. While releasing return. Yes, sure. As a petitioner was an assistant teacher in a government-aided high school.
No, mother.
No.
Mothers.
Petitioner was an assistant teacher in a government-aided senior madrasa who retired on superannuation on 31st May 2022. Stop. It has been submitted 2022. This writ petition is presented, comma, inter alia, comma, challenging the direction of the respondent, authorities, challenging the decision of the respondent authority dated 5th May 2022, whereby the concerned madrasa authority was directed to recast the pay of the petitioner as per ROPA 90 rules. Without treating the petitioner as trained candidate, without treating the petitioner as trained teacher. Stop. Pursuant to such observation made by the Joint Director of Accounts, as it emanates from page 30 of the writ petition, dated 5th May 2022, the concerned madrasa authority, concerned senior madrasa authority, where petitioner was discharging duty as assistant teacher, with a communication dated 15 June 2023, informed the petitioner asked the petitioner to refund rupees 11,16,754, 11,16,754, which was found to be paid in excess for the period from 1st June 1998 to 31st May 2022. Next paragraph, Mr. Ikramul Bali, learned advocate representing the petitioner, submits that in view of the settled, in view of the law decided by the Honorable Supreme Court in the case of yes. In the case of decided by the Supreme Court, reported in law decided by the Supreme Court, reported in 2015, Volume 4, SCC 334, State of Punjab and others versus Rafiq Masi, within bracket Whitewasser, bracket, close bracket, and others. And another judgment reported in 2022 SCC Online Supreme Court, page 536, within bracket Thomas Daniel versus State of Kerala and others. Demand of recovery at the time of processing the pension case of the petitioner due to superannuation is impermissible. So, next paragraph, the learned advocate representing the state respondents has made an endeavor to defend the decision taken by the state respondents, whereby the concerned madrasa authority has been directed to recast the pay of the petitioner for the period from 1st of June 1998 till 31st May 2022 by treating the petitioner as untrained candidate. It has further been submitted that since excess amount was permitted, since the excess amount was drawn by the petitioner upon erroneous fixation of pay, the state respondents are authorized to recover the same at the time of processing the pension case of the petition. Next paragraph, this court has heard the learned advocates representing the parties and peruse the relevant materials available on the petitioner was an assistant teacher who retired on superannuation on 31st May 2022. Stop. The petitioner on acquiring postgraduate degree in history, Mr. Postgraduate degree in history was allowed to enjoy postgraduate scale of pay from the year 1996. From which date?
From MA scale was allowed from 13 June 1997.
13.
13 June.
From 13 June 1997. Stop. However, it has been admitted on behalf of the petitioner that though petitioner acquired postgraduate qualification in history, which was petitioner's relevant subject of teaching, but during the tenure of the petitioner, he did not obtain B.Ed qualification.
On page 21, he was allowed by the ADI, district inspector. He is not joined that automatic. It was allowed
from 13 June.
Page 20. Page 20. In terms of the open. It is not the fact the school authority paid. It was allowed by the ADI.
However, it has been administered on behalf of the petitioner that the petitioner acquired postgraduate qualification in history, which was petitioner's relevant subject of teaching, but during tenure of the petitioner, he did not obtain B.Ed qualification.
Another sentence to the board.
The petitioner on acquiring postgraduate degree in history was allowed to enjoy postgraduate scale of pay from 31st June 1997.
No, from 13 June. From 13 June 1997. In terms of the memo dated 10th May 1999, issued by the Additional District Inspector of Schools within bracket AC bracket closed Kuch Bihar. Could not obtain B.Ed qualification. তারপরে sentence stop. Next paragraph. However, placing reliance on the judgment of the apex court reported in of the apex court, placing reliance on the judgment of the apex court in Rafiq Masi Supra, it appears that concerned respondent authorities are no more concerned respondent authorities are not authorized to recover excess drawn amount from the petitioner who was working in the post of assistant teacher in a senior madrasa at the time of her superannuation on 31st May 2022. Stop. The decision was taken by the Joint Director of Accounts attached to the office of the concerned District Inspector of Schools. On 5th May 2022, which is which was within the month of May 2022. And petitioner retired on the last day of the said month, that is 31st May 2022. In terms of paragraph 18 of Rafiq Masi Supra, recovery at the time of retirement due to on the ground of excess payment cannot be made as a result, cannot be made. Stop. Consequently, it for next paragraph, it further appears that no case has been made out on behalf of the state respondents that petitioner managed to receive excess amount during his tenure.
May I take a lot of credit?
By committing fraud and misrepresentation. So, next paragraph, in view of aforesaid scenario, the decision of the Joint Director of Accounts dated 5th May 2022 directing the concerned senior madrasa authority to recast the pay of the petitioner and to recover rupees and to recover excess drawn amount stands set aside. Stop. The concerned state respondents are directed to settle the pension case of the petitioner in accordance with law, and it will be open to the respondent authorities to fix the pension of the petitioner upon treating him as untrained candidate if it is found that the petitioner was unable to obtain B.Ed qualification during his tenure. On settling the pension case of the petitioner and upon finalization of the same, the District Inspector of Schools, Kuch Bihar, the District Inspector of Schools within bracket AC bracket post Kuch Bihar is directed to forward the pension papers of the petitioner to the office of the Director of Pension, Provident Fund and Group Insurance within 6 weeks from date, within 6 weeks from the date of communication of this order. and the Director of School Education and the Director of Pension, Provident Fund and Group Insurance, West Bengal in his turn shall issue pension payment order in favor of the petitioner within 4 weeks thereafter. Stop. With the aforesaid direction, the writ petition stands disposed of. There shall be no rest cost starting the subject. Whether the Director of Pension is a made party? Yes. Yes.
49.
Yes. Yes, have you completed service?
Yes, I tried to show on the right response, but the physical it's not yet
Come back office. At the time of call, the learned advocate representing the petitioner has prayed for accommodation to complete service of respondents. However, state respondents, you are appealing for the state. Next paragraph, however, state respondents are represented by learned advocate. Stop. Next paragraph, lists the matter before the next circuit, subject to convenience under the same heading. List the matter before the next circuit under the same heading, subject to convenience. In order to enable the learned advocate to the petitioner to complete service or notice upon the response. Next.
Item number 50.
Last commission was regular stated direction to take instruction regarding the status of the petition.
This is item number 50.
50.
Yes, what is the instructions?
I am from the sector. We have followed the my instructions with them. We have taken action after the appeal, last appeal communication and forward the copy report.
No, there is a 26th April.
Yeah, that we have followed it. I latest communication with the accountant general on 10th May.
What is the 26th April memo?
That is not okay. Well, I have a copy of the pencil.
Just let me find it. Perhaps it is not annexed to the writ petition.
No, because actually
yes, it is there. So there was a requirement of refixation of pay of the petitioner in terms of memo dated 26th April 2023 issued by Senior Accounts Officer, Indian Audit and Accounts Department. So your instruction is you have done this.
We have forwarded it on 10th May to the accountant general and some of the.
Where is the forwarding letter?
No, that's just send it over. I have another copy.
Just a minute. 10th May.
Instant.
देखो तो उनका
The date is after the 2 then the date.
This document.
That is pending to the accountant general. That I do not represent.
Yes.
That is already sent 12/7
What you have seen? They have forwarded you. You have tried to apply your mind that there was a request made by the Senior Accounts Officer, Indian Audit and Accounts Department, directing the district judge, office of the district judge to recast the pay, and the pay was recast. And subsequently, video memo dated 10th May 2023, it was sent to the Accountant General A&D, Audit and Accounts Department. Yes. So what steps you have taken after receiving the same?
Already.
This one. Yes, tell me that what steps you have taken. It is the communication which has been made by the Indian Audit and Accounts Department to the advocate. This is a secret document. This should not be divulged before this court. You have to make your submission based on the instruction which you are receiving.
Already this one.
Yes.
Already this one.
Already
sent. Already sent.
Just a minute. Advocate's instruction is being placed before me.
Already sent.
Yesterday.
It has been sent to Treasury Jalpaiguri. Stop payment.
Yesterday.
So shall I dispose it of? Directing the Treasury officer to release them all. Petitioner was working in which post? Senior solicitor. Where you have stated? Post of clerk at the office of the respondent.
Group 1.
Bench clerk group 1.
Group 1. Because individually the
Promoted to the post of senior solicitor.
promoted to senior solicitor.
SHERESTADAR. Senior solicitor. Petitioner retired on superannuation on 31st March 2020 from the post of senior solicitor under the judgeship of Jalpaiguri, under the district judgeship of Jalpaiguri. Stop. Petitioner has claimed benefits under the relevant RUPA rules upon revision of his pay. Stop. Next paragraph. The matter was heard previously on 11 July 2023 when it was brought to the notice of this court that video communication dated 26 April 2023 Senior Accounts Officer of Indian Audit and Accounts Department requested the office of the district judge Jalpaiguri to revise to make necessary fixation of pay of the petitioner for extending the benefit as claimed by the petitioner. Stop. Today it has been submitted on behalf of the office of the district judge, former Jalpaiguri, that video communication dated 10th May 2023, upon making necessary pay fixation of the petitioner, the papers relating to service of the petitioner were forwarded to the office of Indian Audit and Accounts Department for taking necessary steps. Stop. Next paragraph, the learned advocate representing Indian Audit and Accounts Department submits some instruction that on 12 July Treasury Officer, Jalpaiguri -Roman 2 was communicated to make necessary payments in favor of the petitioner, and in support of the same, a communication dated 11 July 2023 of Senior Accounts Officer is placed before this court, which is taken on it. Next paragraph. in view of the steps taken by the concerned authority of Indian Audit and Accounts Department, as it appears from the communication dated 11 July 2023 of the Senior Accounts Officer of Indian Audit and Accounts Department. The Treasury Officer, Jalpaiguri Roman 2 is directed to release the amount as sanctioned by the concerned respondent authorities in favor of the petitioner within a period of 3 weeks from the date of communication of this hospital. Yes. Then within a period of 4 weeks from the date of communication of this order. Stop. Next paragraph. Next paragraph. Accordingly, the writ petition stands disposed of. There shall be no orders to post. Next paragraph. The treasurer, the learned advocate representing the petitioner is granted leave to amend the post title of the writ petition and add Treasury Officer, Jalpaiguri Roman 2 as additional respondent. In course of this day, stop. The learned advocate for the petition is further directed to communicate this communicate this order along with the copy of further directed to send or further directed to serve copy of this writ petition along with the order passed by this court today. Upon the Treasury Officer, Jalpaiguri 2, within 7 days from date. Stop. The learned advocate representing district judge, representing the office of district judge, Jalpaiguri is also directed to communicate this order to the concerned Treasury Officer. Stop. Next paragraph. Urgent Xerox certificate copy. Immediately you amend the post title and add Jalpaiguri Treasury Officer Jalpaiguri 2. Yes. Disposed of. Next.
Item number 51.
Yes.
Yes, not. I think to submit one digital pathway or a possible by paragraph 23. WPA number 21710. Paragraph 23 below.
Yes, that's good. Yes, please read the read paragraph 23. Please read paragraph 23. Which you are relying upon.
Paragraph 23.
Paragraph 22.
Upon considering the submission from the parties, it is evident that Krishna has not only claimed a refund of all proceeding fees from the respondent of court, a private bank, but has also challenged the communication taken June 12/17 of the assistant manager CPC which closed the dispute raised by the Krishna regarding return of processing fee. Since the Reserve Bank of India is the instrumentality of the state, it comes squarely within the meaning of state as contemplated in Article 12 of the Constitution. Thus, the distribution is maintainable. That apart, the function discharge by the respondent of court banks of public nature and as such pertain to the discharge of public duties. The question raised by the petitioner in the present petition is not restricted to the grievance of the petitioner, solely all such grievance from the cause of action of the petitioner, but also has a wider connotation in so far as the liability of banks in respect of refund of processing fees concerned. Here the objection regarding the maintenance.
So liabilities of banks in respect of refund of processing fees.
Yes.
So it's a matter in between the bank and the customer.
That's true.
Yes, so see, in the case of CESC matter, Calcutta State Electric Supply Corporation, there you will find that with regard to the grievance of the customer relation to supply of electricity or generation of inflated bills, writ petition is maintained. But regarding service dispute, writ petition is not maintained. In a different context, it has been held by the coordinate bench that it is the functions, since the functions of the private bank is public in nature, therefore it should be regarded as a state, and it should be regarded as a state as enshrined under Article 12 of the Constitution. But when there is a dispute, we intersect between the bank authority and the employee, whether this analogy will apply.
Yes, Milord. I got a decision. I got another decision. This is the employees against the Sonali bank. I'll come to that. Next, in this document, para 34 is being referred to. Para 34. Only two sentences. And see both the sentences, first and second sentence. 34.
Para 34.
Yes. I will submit that this will probably eliminate all the doubts. This particular sentence.
Just a minute. Please read the first sentence.
However, on the facts of this case, respondent of court, while discharging its public duty, which is within the domain of the state, which discharge acted rehearsed its own promise of refund, on which the petitioner acted, which debarred respondent of court by the principle of estoppel from refusing refund of process.
So that is with regard to refund.
But
so that's why, since the bank is discharging public duty in public domain, because it is a matter or dispute in between the bank and the customer, with regard to refund upon relating to processing fee. That's why court has held that bank is discharging the public functions, therefore writ petition is maintained. But today this court is tasked to consider whether when an employee of the said bank has been suspended, whether such suspension can be challenged by filing a writ petition or not?
It is in public domain, I must submit. I submit.
Suppose that an employee of ICICI Bank Limited, can he file a writ petition against the bank authority for termination?
Bipartite agreement is there. Bipartite agreement is there. And in by this,
File your affidavit. Sorry, I have reservation in this matter.
let them file a affidavit of it.
Yes.
Only one period of time.
You are happy?
Yes, yes, yes. Yes, yes. It will be taken over.
Solicitor is applying for that.
Who is appealing for the bank?
I am my brother deputy solicitor is applying for that.
How can he identify me, but
Please, please, I mean, why you are making this issue complicated, sir? Yes.
I appear for Sonali Bank, the senior.
The writ petition is heard in presence of the learned advocates representing the petitioner and respondent number 3.
Yes.
And respondent number 3, 4, and 5. Stop. In the writ, next paragraph, in the writ, next paragraph, the petitioner has challenged the order of suspension dated 8 May 2023 issued by the concerned authority of HON'BLE Bank Limited. Stop. Next paragraph, Mr. Sudipto Majumdar, learned senior advocate representing HON'BLE Bank, has raised the point of maintainability of the writ petition against the said bank, since it has been submitted that this is a private bank. Stop.
Private bank.
This is a private bank in India. This is a private bank in India. Stop. Next paragraph. Next paragraph. The issue involved in this writ petition needs to be decided after calling for affidavits. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed within 3 weeks from date. Reply thereto can be filed within 1 week thereafter. Stop. The writ petitioner shall be at liberty to mention the matter before the appropriate. Shall be writ petitioner shall be liberty to mention the matter before the next available circuit for hearing after the time fixed here hearing above for exchanging affidavits. Stop. Next paragraph. However, point of maintainability as raised on behalf of the bank authorities kept open. Next paragraph. Parties shall act on the server copy of this order downloaded from the official website of this court. Next, 52.
I am for the petition, my lord.
আপনাদের appearance for the petitioner.
My lord,
Yes.
my lord, this is a matter as regards to refund, my lord. This needs an exchange of affidavit, my lord. Under the GST Act, my lord, it is a matter of refund, my lord. Whereof, my lord, out of the total amount of 3 crore 43 lakhs, 3 crore 43 lakhs, my lord, 3 crore 10 has been refunded to me, but 32 lakh has not been refunded, my lord.
Very good.
And, my lord,
Record and order. The writ petition is taken up for consideration in presence of the learned advocates representing the petitioners and which authorities you are representing?
State GST authorities.
And state GST authorities. So, the learned advocate, next paragraph, the learned advocate representing the petitioners submits that there is no scope of passing any interim order, and the issue needs to be decided on exchange of affidavits. So, next paragraph. Accordingly, next paragraph. Let affidavit in opposition to this petition be filed within 4 weeks from date. Affidavit in reply thereto can be filed within 2 weeks thereafter. Stop. Parties shall get liberty to mention the matter before the next available circuit for hearing after the time fixed hearing above for exchanging the affidavits. So, next paragraph, parties shall act on the server copy of this order duly downloaded from the official website of this.
Grateful Lordship.
Yes.
Now the here.
53.
I am appearing on behalf of the respondents. STL, that is the submission. The respondent number 1 and 2. There is a missing the link. Yes, now it has come. I am the respondent number 1 and 2 appearing with Mr. Sumit Roy.
It got an order. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, respondents are represented by learned advocates. Stop. Next paragraph lists the matter before the next subject. Subject to convenience.
The matter is fixed. I can't. Very difficult to hear me. Miller, the matter is fixed, Miller. Excuse me, my lord, the matter is fixed on. I am the respondent number 1 and 2.
Next circuit, no one appears for the petitioner.
Lordship. Next.
Yes, you are appearing for petitioner. 54. This is item number 54. 54. I
have the statement.
They are calling the affidavit of service. Service upon the private respondent has come back with the endowment refused. What you are paying for? Paying for my lord. What happened is that I had filed for police complaint. We have filed a police complaint. In which my lord has alleged that I belong to the scheduled caste community, and delegation offence has been tried to be submitted against them. What had happened, my lord? The FIR was registered, but not under this CSPI. What is your complaint? Yes. Kindly come to page 14 first, ma'am. Just a minute, let me see the prayer. Yes. Written complaint dated 28 November 2023. By invoking the relevant sections. Sorry. No, it's a important issue. And in the prayer you have done this. On this basis, I cannot pass any order at all. No, then madam, can you grant me liberty to correct it, madam? Because the document at page 16, the written complaint, my lord, that is the date is correct. File your supplementary agreement. Prayer cannot be corrected by granting me. It's not a cost item. Issue. The writ petition is taken up for consideration today in presence of the learned advocates representing the petitioner and state respondents.
Yes,
and state respondents. Stop. Next paragraph. However, on perusal of However, next paragraph, however, on perusal of prayer A of the writ petition, it appears that petitioner has prayed for an order based on a written complaint dated 28 November 2023. Which is a preposterous prayer, which is a preposterous prayer, preposterous prayer. Stop. Next paragraph, learned advocate representing the petitioner submits that there is a typographical error which has occurred. Has submitted, learned advocate representing the petitioner has submitted that this has submitted that there is a typographical error. There is a typographical error. Stop. Next paragraph. In view of next paragraph. In view of the case, petitioner is granted leave to file supplementary affidavit disclosing the correct facts pertains to this writ petition. Stop. Let's supplementary affidavit be filed within 2 weeks from date with an advance copy of the learned advocate representing the state respondents. Next paragraph, the petitioner shall get liberty to mention the matter before the next available circuit for inclusion. For next available circuit after filing of supplementary affidavit. Next paragraph, affidavit service filed on behalf of the petitioner is taken out. Next, 55.
I am appealing on behalf of the respondent who put to sir.
Yes. Who is for the petitioner?
I take 55 to 60 and 60. Mr. Subon Shah is that it. I think happening. But then, request.
At the time of call, learned advocate representing at the time of call, accommodation has been paid for. Accommodation has been paid for on behalf of the petitioner. Since the learned advocate representing the petitioner is not well. Stop. Next paragraph. However, respondents are represented by learned advocates. Stop. Give your appearance. Next paragraph. List the matter before the next circuit, subject to convenience. Yes.
55 to 60.
One after another.
56.
56. Same order. Same order.
58.
Same order.
59. 60.
Yes. 60 दिखेगा उसको आते हो
63.
Same order.
आइटम नंबर उनके नाम देंगे 61. Jayaraj Gupta.
Bishop. At the time of call, accommodation has been paid for on behalf of the petitioner. So, next paragraph. However, respondents are represented by learned advocates. So, list the matter before the next paragraph. List the matter before the next circuit, subject to convenience. India. Next.
62. The respondent.
Petitioner.
Water. Which notice to by your current it is the petition. Now the new involving the petition whether was the solution from the state insurance corporation act will be applicable. If the act, the solution of the act is applicable in my case, then I have to abide by this. I don't. I'm challenged to portions of interest they are all applicable in my case.
You are appealing for which authority?
Interest rate insurance, all the respondents.
No.
Whether any notice has been issued by the Provident Fund authority?
Yes, Lordship. We have issued two proceedings.
So,
Page 78.
No.
Yes, what happened on 5th June 2023?
no, I'm coming to the original. Now the petitioner is Tanya Trading, Tanya Trading, Tanya Marketing Company. It is in the business of selling electronic items. There is a showroom, there is electronic items, now look at this number 90. This is my answer 3. The officials of the PSI corporation, they visited my establishment on 26 May 28, 2011, and they have prepared a visit note.
Yes.
In the visit note, visited MS Tanya Marketing Company, first floor, National Research Center. Officer in charge was contacted by the time. In one Shamol Graha stated that the attendance expert in the custody of the Nirmal Dirasana partner with what Mr. In Shamol Graha stated that 7 staffs were in this office, the names of the 7 staff are this.
Yes.
So they have come to my establishment to inquire how many staffs were working. I have to that 7 staff, and out of the 7 staff, 2 staff they belong to the gate arrow water purifier. So I have given them the number 7.
So apart from 7, there are 2 staff. They are not staff of Tanya Marketing, but they are staff of Kane Taro.
Now,
how many staff are required?
10 staff.
Admittedly, it's 8 staff.
So in order to come under the ambit of ESL corporation,
the minimum 10 staff are required, and rightly pointed out the where
Now, on the basis of this visit note, what was the decision? That that notice was given.
Yes,
No,
Lordship.
the-
They have not enclosed all the visit notes here, Your Lordship. We have find 12 employees working there. There were 2 units. One, there is 7 and in another unit, there are more than 4 or something.
So, according to your calculation,
Yes, there are
how many staff are there?
more than 10. More than 10. What they have annexed here, there is 1 unit, Lordship. They have multiple units running in Siliguri, Lordship.
If there is a multiple unit of one organization, then all units have to be taken together. While completing the number of staff.
They comes under the same category known as company, Lordship.
Under which provision you are making this submission?
Because they have the one company, Lordship. They have
How is a partnership fund? Proprietorship fund. In the personal project sheet, Tanya Marketing, both the names Tanya Marketing Company, it's a proprietorship. In the activity project,
It's not a partnership fund.
it's not a partnership.
Show me the provision that under which if a company has several units, then all units are
It's a partnership fund.
in case of a proprietorship fund.
It's a partnership fund, and they have in one unit there is 7, and in another. But the thing is that Lordship, under one heading, when they are contributing the employee state insurance, they are paying the insurance under one heading. So when there is one heading, it should be treated as one company, and for that reason, they have come under the provision of employees.
My query is specifically to you. That if the organization or the company is a proprietorship fund, then if there are several units, then in case of proprietorship fund, all the units are to be taken together.
Lordship, what
Satisfy the query of the court.
we have to file an affidavit, Lordship. But there is
Then let it be stayed.
Lordship, the thing is
Then
that
let it be, because you will file affidavit in the meantime, you will go on with the proceedings, and petitioner will be pitted against all odds that
Lordship, this kind of disputes, there is another alternative remedy, Lordship. They have a employees insurance code, Lordship, under section 75(1)(g), Lordship.
Kindly see what are the jurisdiction of the court. Kindly see.
Any dispute between the principal employer and the company, that is to be
now
taken.
whether this is a submission in disparation. You have not taken this point at the threshold.
Lordship.
When you have been asked to answer the query of the court, now you are taking the point of alternative remedy. What sort of stand is this?
Lordship, let the affidavit be filed. Let me file the affidavit, Lordship.
The writ petition is presented, inter alia, challenging a notice dated 10th May 2023, challenging a show cause notice dated 10th May 2023, whereby petitioner company was whereby petitioner was asked why warrant of arrest should not be issued against the petition. Next slide. During course of hearing, the learned advocate representing the petitioner submits that the representatives of ESI Corporation, representatives of Employee State Insurance Corporation visited, or officials of Employee State Insurance Corporation within bracket officials of Employee State Insurance Corporation within bracket, for short ESI bracket close.
During course of hearing, the learned advocate representing the petitioner submit that the officials of Employees State Insurance Corporation will be making for stop ESI
inspected the, it's a shop or shop, inspected the shop of the petitioner on 26th May 2011, and a visit note was prepared, which is at page 19 of the written petition. Stop. From the said document at page 19, it was disclosed by the concerned authority of ESI that 7 staff were working in the shop of the petitioner. It has also been submitted that in order to attract the provisions of, what is the relevant act?
Employee State Insurance Act 1948.
Employee State Insurance Corporation Act or Employee State Insurance Act 1948. Minimum 10 staff are required to be found working in the establishment, and also they have to be involved in manufacturing process. It has been, next paragraph, it has been contended on behalf of the petitioner that since 7 staff were found to be present in the shop of the petitioner and they were not involved in manufacturing process, therefore the provisions of the said act, we operate within bracket hereinafter refer to the said act, of 1948
it has been contended on behalf of the petitioner that since 7 staff were found to be present in the shop of the petitioner and they were not involved in manufacturing process, therefore the provisions of the said act of 1948
are not applicable in the case in the present case. There is another link of submission made on behalf of the petitioner that the organization, that the establishment of the petitioner is a proprietorship firm and it is not a partnership firm. Therefore, in case of proprietorship firm, if there are other staff engaged in other shops under the said proprietorship firm, they are not to be counted while taking decision whether the provisions of the said act of 1948 shall be applied or not. Next paragraph, the learned advocate representing ESI has disputed the has opposed the prayer of the petitioner and has submitted that there are other shops of the petitioner and officials of ESI visited those shops on different dates and other visit notes were prepared from where it can be ascertained that if all the shops of the petitioner are taken into consideration, the total number of employees will be found to be more than 10. Stop. Therefore, the notice dated 10th May 2023 ought not to be interdicted. However, the learned advocate representing ESI has prayed for opportunity to file affidavit in opposition to this writ petition. Next paragraph. The question arises for consideration in this writ petition is whether, in case of proprietorship firm, all the establishments / shops are to be taken together in computing total number of staff employed there, or shops are to be assessed separately. This court, while posing query to the learned advocate representing ESI, does not get any satisfactory reply that whether there is a provision under the said Act of 1948 which empowers the concerned authority of ESI to take into consideration all the establishments / shops of proprietorship firm while computing the number of employees engaged there. It appears matter needs to be decided after calling for affidavits. Next paragraph, accordingly, next paragraph, let affidavit in opposition be filed within 3 weeks from date, and affidavit in reply thereto can be filed within 2 weeks thereafter. Stop. Next paragraph, parties shall get liberty to mention the matter before the appropriate before the next available circuit after the time fixed herein above for exchanging affidavits. Next paragraph. The notice dated the impugned notice dated 10 May 2023 issued by the recovery officer, Employee State Insurance Corporation, shall remain stayed until further on. Next paragraph, parties to act on the server copy of this order downloaded from the official website of this court. Yes.
61, I was addressing courtroom number 1. If you logic can I take it up tomorrow?
Sorry, at this stage it's not possible. Tomorrow there will be less number of matters.
So my tension has been started.
Sorry. Next.
Item number 63. 4. Item number 64.
64 তো হলো যে রিজিওনাল করুন না 64 হবে নেক্সট বলো এটা আগেটা 62 বলো হ্যাঁ 63 আগে হয়েছে 7 হলো
64 the same method of letters.
As prayed for on behalf of the petitioner, let the matter be placed before the next subject. As prayed for on behalf of the petitioner, let the matter be placed before the next subject to consequence.
65.
My lord, I appear for the petitioner. My lord, a sad incident has happened here in my lord. My son, my lord, he is a doctor of North Bengal Medical College.
Your son?
Yes, petitioner's son.
I thought your son is a doctor.
No, my lord, petitioner's son. Petitioner's son is the, my lord, doctor.
That's why I am astonished having seen your, having heard your submission. Yes, yes.
My lord, I have made mistake, my lord. If well, petitioner's son, my lord, is a doctor by profession, and he was posted in North Bengal Medical College, Saurabh Roy, and on and from, my lord, 3rd of April 2023, my lord, in Shebok More, he was found missing. Several general diaries have been made before the concerned police station, and he is having. My lord, in this, I have prayed for a report from the concerned police officer to file a report as to the whereabouts of the son and to inform the petitioner whether he is missing or the son is dead or alive.
Mr. Banerjee, for that you have to pray, since the petitioner's son went missing and you require production of son before this court or the report to be filed before the court. So therefore, in order to file a report, the son of the petitioner has to be traced out.
Yes, that is what is the report, what is its condition. Only that much a report.
Withdraw the writ petition, file and habeas corpus petition before the division bench.
But habeas corpus I may file, but I have prayed only for a report.
Follow the procedure. Follow the procedure. Your son has gone missing. So therefore, you want his appearance before this court, or at least the son.
I have not prayed any. I have not made any appearance before this court. Only a report of the.
But a report means his whereabouts has to be traced out.
Traced out, yes, my lord. Yes.
The appropriate course which is left open to the petitioner is to file an habeas corpus petition.
Habeas corpus, my lord.
Petitioner will be benefited. This court has no jurisdiction to hear out.
Habeas corpus, my lord, to bring him to the court. I am not praying that.
It is a rich petition in disguise of habeas corpus. Try to appreciate the position.
I can. What has fallen from your lordship, I can. That's just only a report if the police officer may file.
No, sorry. Considering the grievance of the petitioner, you withdraw the writ petition, file the appropriate, take appropriate steps in accordance with law.
That liberty may be given.
Yes, yes. He will get the liberty. What? The writ petition is taken up for consideration when Mr. Banerjee, Mr. Vikram Banerjee, learned advocate, especially the petitioner, has submitted that the petition and has submitted that petitioner's son went missing from which day?
3rd of April, my lord.
Petitioner's son went missing from 3rd April 2023. From Shebok Road.
From Shebok Road. Shebok Road.
From a place in the district of Darjeeling. From a place in the district of Darjeeling. From a place in the district of Darjeeling.
From 3rd April, from a place.
From 3rd April.
From a place.
From 3rd April 2023. From 3rd April 2023. Petitioner has prayed for filing of report by the concerned police authorities on such missing incident. So, next paragraph. State respondents are represented by learned advocates. Next paragraph. Having considered the grievance voiced on behalf of the petitioner, it appears that the writ petition in its present form is not maintainable. Petitioner ought to have made a prayer for issuance of writ of habeas corpus. So, next paragraph. At this stage, the learned advocate representing the petitioner has prayed for leave to withdraw the writ petition and to file appropriate and to file habeas corpus petition before the honorable division bench. Stop. Next paragraph. In view of next paragraph, accordingly, the writ petition stands dismissed as withdrawn with a leave, with leave to the petitioner to take appropriate steps in accordance with law. Stop. Urging Xerox and wait for that.
66.
Take appropriate steps, Mr. Banerjee.
Yes, I will take.
Yes, service is not complete. At the time of call, accommodation has been paid for on behalf of the petitioner for effecting service of notice upon the respondent. Stop. Whether anybody is happening for the respondents? No. Stop. Next paragraph, let the matter appear before the next circuit, subject to convenience, in order to enable the learned advocate representing the petitioner to complete service upon the respondents. Next.
67
minus 67 to 61, then submission.
67 to 61.
7 minus 71. 71. 67. 70. I know. I got the habitational conflict and it
Same order. Call one after another.
68.
Call one after another.
67, 68.
minus same service.
You are appealing for the petitioner.
69. 70. 71. Now. 72. Between single.
Yes, sir.
Yes. He has not been properly speeched. Speak. Paginations, there are defective paginations. After page 24, there is 23, 24, then 25.
24 is the part of the petition method.
After 23, after 24, there is 23. Then again, there is 25.
Document static for is not 29.
Thing is that their paginations are defective.
Even if it's not.
And it's taken up for consideration when on perusal of the writ petition it appears that pagination is not in order. The learned advocate referring to the petitioner granted leave to rearrange the pages of the writ petition in presence of the court officer. Assistant court officer, no? In presence of the assistant court officer of this court. Stop. Next paragraph, this is the matter before the next further consideration. Next. 73. prayer part next matter 73.
Petitioner. And the petitioner was uninformed information.
Yes.
And he worked against a veteran sanction group D post.
Approved staff.
Not.
No, what is claiming?
The thing is that he retired from 30th April 2020. Thereafter, PPO was in his favor. He started to get the pension. All of a sudden, from month of March 2020, the pension stopped.
Who is appearing for which municipality? Kalimpong municipality. Who is representing municipality? Have you served upon the municipality? State will come later on. First municipality. At the time of accommodation has been paid for on behalf of the petitioner to complete service of voting. However, state respondents are represented by learned advocates. Release the matter before the next circuit for further consideration. 74.
74 Milord, 74 Milord, I am for the petitioner. Milord, 74, I am for the petitioner, Milord. I am appearing virtually, Milord. 74 Milord.
Why you are appearing virtually?
Milord, from Kolkata, Milord.
You are not an aged person, aged lawyer.
No.
Then
no.
Why you are appearing
virtually, Milord? My lord, this is the transfer matter, and my lord, petitioner willing to transfer, but due to portal suspension, petitioner is not able to make any application before the portal. Let the petitioner liberty right be reserved and liberty be given at the time of opening of the general transfer. That's my prayer, my lord. That is only my prayer.
Well, who is appearing for the school? For the school service.
My understanding is not focus on
When you have applied for transfer, Mr. Ghosh Chaudhary, when you have applied for transfer,
my lord, first time, my lord, first time I applied, my lord, on 31st of August 2021, page 17. Page 17.
Yes. Yes.
31st of August.
What is the date?
That time, my lord, column 6, 31st of August 2021. Page number 17, my lord, of my application.
31st August.
31st of August 2021.
Page 17.
Yes, my lord, task page, that is page 17.
This has been rejected on the prior page, not page 16.
My lord, last application is medical. My lord, my last application.
31st August 2021, you made application. Now,
Transferred in any other ground. My lord, in any other ground. It is not on medical ground.
Now, is saying
my lord,
your transfer application has been rejected.
On the 10%.
rejected, my lord, rejected, first rejected, my lord, on, my lord, 30th September 2021, 30th September.
So that was rejected
30th September.
on the ground of 10%. So let me dispose.
10%.
Let me dispose of your application, granting you leave to make an application when a scheme will be floated by the School Service Commission or the respondent authorities for transfer.
Lordship. But not all general transfer. I don't know in which form it will be appear. Which form it will appear. It will open, my lord. Either online or offline. It's a general transfer.
From which date it is under suspension in that matter?
23rd of September 2020.
29th of 2000. Petitioner, you are presently working as an assistant teacher.
Yes, my lord. Yes.
Petitioner is an assistant teacher of a government-aided high school who is seeking transfer to the schools which is nearby to her her place of
residence.
Each place of residence.
Yes.
Previously, petitioner made an application on Utsoshi portal seeking transfer upon indicating 3 options. However, the application of the petitioner was rejected by the concerned authority of West Bengal Central School Service Commission, since it was found that under the relevant rules, petitioner was not found eligible to be transferred. Next paragraph. It has been submitted on behalf of the learned advocate representing West Bengal Central School Service Commission that at present Utsoshi portal has been suspended. Therefore, there is no scope so far. Teachers working in secondary schools to make an application for transfer on using the said code. Next slide. In view of suspension of Utsoshi portal, on which teachers working in secondary school can make application for transfer, no relief can be granted to the petitioner. And accordingly, the writ petition stands disposed of. No relief can be granted to the petitioner. Stop. Next paragraph. Granted to the petitioner. Stop. Next paragraph. The writ petition stands disposed of upon granting leave to the petitioner to make application for transfer when applications will be invited by the West Bengal Central School Service Commission from the teachers who from the teachers for transfer.
Lordship.
Yes, sir. More or less to cost at the end of the service. Service filed on the next.
Disposed of 75.
My lord.
This is
75, my lord.
This is item
75, my lord.
74.
70.
Yes, disposed of.
75, my lord. Similar relief I am seeking. My lord, Only one indulgence, my lord, one page has been missing that I am filing. My lord, similar prayer, my lord. Now petitioner is seeking transfer but cannot
transfer. Previously, have you
similar? Yes, that page I am missing because suspension of the scheme. Ultimately, I collected that page and my lord, I am handing over. My lord, kindly see that page. My one of the junior colleague is giving that copy.
Where is that page? Where you have stated in the writ petition that you made an application for transfer.
My lord, one thing I am candid before your lordship. Since any other ground I did not make any application, but that which is why, my lord, at that time I know information, which is why I have stated that no application has been made. But subsequently, my lord, it has been come that my lord, that application has been in portal. That is why, my lord, I am submitting, my lord, that paper, that page before your lordship and seeking same relief, my lord. Prayer is same, my lord. Prayer is same that I am seeking liberty that my when the general transfer will open, that my accordingly, my lord, reserving my right, I shall apply. But the prayer is the same. Similar to 7.
There is not going to be.
Only liberty leave which is granted by the petitioner, by this court to the petitioner is that when there will be an opportunity to which will be provided to the teachers to pray for transfer, then petitioner shall make an application seeking transfer. Nothing else. Same order. Yes.
Number 76.
My lord,
what is
my
it?
lord, 76. I want, my lord. It is and my lord, this is the general transfer. My lord, this point I am agitating some anomaly in the order sheet, my lord. My lord, kindly, my lord, petitioner is agreed by a whimsical order of the DI. My lord, I am order impugned, my lord. Kindly see page number 18.
It is not the same issue.
Not same issue.
Not same issue.
It is stateway.
Not same. For the next circuit,
All these matters are the same. By the DI, all these matters.
My lord, only DI in this matter, one report from the DI is essential, my lord.
Maybe whether there is a from the DI. He's mentioning it on under 76 matter. If you why not take the 74 matter also, there is no rejection from the DI.
rejection of the DI should for the application of the petition.
Yes.
Due to suspension of the portal.
No, I suspended from 10%.
My lord, 10% is not applicable. My lord, 10% is not applicable. My lord, against me. My lord, only, my lord, kindly see only once. My lord, kindly see paragraph number 7. My lord, kindly see paragraph number 7 of my petition, my lord. My lord, kindly see paragraph number 7 of
representing the state respondents and service commission that in all the matters, in 2 matters, I have passed an order, but there also the DI has rejected your prayer for transfer on 10% ground. So unless until the order of DI is set aside, where is the scope for permitting?
Yes, my lord. But that is purportedly
no.
My lord, that is purportedly illegal. My lord.
Sorry, Mr. This is not the way.
Lordship.
The order of the DI set aside, this court cannot grant you leave to make an application for transfer. Otherwise,
my lord, I am seeking that. I am the. My lord, I am seeking the.
Order of
I am seeking the.
Sorry.
My lord, I am seeking the setting aside the order of the DI, my lord. My lord, I am seeking the setting aside order of the DI.
Matter is the consideration when Mr. Ghosh Learned Advocate representing the West Bengal Central School Service Commission has prayed for accommodation to take instructions. So, list the next paragraph, list the matter before the next circuit for further consideration.
Lordship.
Evidence service filed on behalf of the petitioner is taken on the person. Similar order in item number 75.
75 is different.
No, my lord, it is 74. 74 is similar.
74, 75, and 76. And 77 and 76. Item number 77.
77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77. 77 or 77.
77 similar to 74, my lord. Similar to 74.
Up to 77, same order. Mr. Ghosh, you are appearing in on behalf of the commissioning on the matter. Next circuit, take instruction.
My lord, 74 is not disposed of. My lord, 74 is not disposed of.
No, not a single matter is disposed of. All matters
Lordship,
come up into the next circuit. And the commission is land advocate representative commission is directed to obtain instruction.
Lordship, very.
Thank you.